The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, Mr. Hume.
Good morning, Your Honor. Good morning.
May it please the court, Hamish Hume for Appellant Blenheim.
Why don't you lift up the microphone onto the podium so we can hear it?
Yes, thank you, Judge Niemeyer. Hamish Hume for Appellant Blenheim Capital. Your Honors, if it pleases the court, I plan to begin with the Foreign Sovereign.
If you're willing, it'd be easier to hear you if you removed your mask when you talk too, but you may want it on.
No, I did not want it on. I simply forgot to take it off.
But just during an argument, yeah.
Your Honors, I plan to begin with the Foreign Sovereign Immunity issue and then address the antitrust issue. Plaintiff Blenheim Capital brought claims against the Republic of Korea and its Defense Acquisition Board, DAPA, based upon tortious conduct that was part of a commercial transaction with substantial contact with the United States. Under the plain text of the Foreign Sovereign Immunity Act, those claims were based upon commercial activity carried on in the United States, and the Korean defendants were not immune from suit. The district court erred in reaching the opposite conclusion because it failed to consider the specific tortious conduct the claims were based upon and the specific commercial transaction that tortious conduct was a part of. I'd like to quickly summarize the commercial transaction and the tortious conduct, because Blenheim alleges that DAPA conspired with a United States company, Lockheed Martin, to remove Blenheim from a commercial transaction to acquire a satellite that was to be delivered here in the United States and launched into orbit from here in the United States. A few quick facts about the transaction itself.
How do you define commercial activity, commercial transaction?
The way the
And why is this a commercial transaction?
As the FSIA says in Section 1603D, it's the nature, not the purpose, that matters. And as the Supreme Court said in Weltover, that means you do not look at the purpose of the transaction. You look at only the outward form of it. And in Weltover, the Supreme Court said that a sales contract for goods is a commercial transaction, even if it's military equipment, as the legislative history says, even if it's for a military purpose. It's the outward form that matters. The virtual defense case applied that principle to say that even the sale of MiG fighter jets capable of firing nuclear weapons is a commercial transaction, and that was cited favorably in both the Ninth Circuit and the 11th Circuit. The Ninth Circuit in Ministry Defense versus Cubic, these are cited in our briefs, and the 11th Circuit in the Samco case. The Samco case involved the acquisition of arms, munitions, and explosives, or the bailment of those military equipment. The Cubic case involved the acquisition of an armed combat.
Are you arguing that the sale of the F-35s
No.
is a sovereign act?
Right now, Judge Niemeyer, I'm solely focused
I know you are,
on the
but
satellite.
I'm moving a little broader, and this transaction involved the sale of F-35s to Korea. Is that a commercial transaction?
We've argued it is, but I want to be very clear that the court need not reach that issue.
I understand that. You say this is collateral, it's a different nature transaction,
That's
your argument, but I'm focusing now on the transaction of F-35s. You said the sale of MiGs. It seems to me the test is whether we are focusing on conduct of a sovereign who's exercising its prerogatives as a sovereign. We know the old doctrine that governments can engage in commercial activity. But it seems to me that when South Korea buys F-35s, number one, only a sovereign can buy them. Number two, it's buying them for its self-defense. Number three, it's a transaction essentially between the United States and South Korea. You can't sell them except through the United States. So it seems to me those aspects make it a sovereign transaction, right?
Your Honor, I think the third is the only thing different from the existing case law. Under the first two, that only a government can buy it and that it's buying it for a military purpose, that is true of the facts in virtual, for example, which is cited favorably in the 9th and 11th Circuit. The existing case law has applied the principle of weltover differently in the situations that involve the first 2 points you made. The third point, I'll admit, is different and not addressed in any case except for the Simon case and the BAE District Court case. Nevertheless, and so I realize that the FMS transaction presents different issues that make it a harder case as to whether the F-35 transaction itself was commercial. But I really want to emphasize, because the critical error here and the issue we wish to focus the court's...
I know you want to get off, but I want to explore just a bit why the F-35s is not commercial or is. I mean, you're saying it's not commercial, it's a sovereign transaction.
No, I'm not saying that.
Oh, you believe it's a commercial transaction?
We've argued it is, and we believe it is, but...
Well, then it's hard for me to tell what a sovereign transaction is, because South Korea was trying to improve its national defense by buying materiel that could only be supplied to it from another sovereign.
The first point, that they were trying to improve their defense, that goes straight to purpose. I'm 100% confident that cannot be the test.
Well, tell me what the test is then.
The test is simply whether the outward form of it is the same as a sales contract for the purchase of goods, no matter what they are.
And no matter who they're sold to or from?
That's correct.
That just can't be the case, because a sovereign, in exercise of its sovereignty, can buy stuff necessary to act as a sovereign and solely, uniquely as a sovereign.
I'm simply trying
You're arguing as a general level that any contractual relationship is per se commercial. Is that what your argument is?
That is the argument as to the F-35s, but you can...
Anything. Any transaction involving a sovereign that is a contract, you're saying is commercial, because contracts are inherently commercial.
Yes, Your Honor.
Okay.
But you can reject that argument and still rule for
Well, I
us.
find it hard. I'm going to want to read some more.
Well, I'd rather the time be focused on
Yes, sir.
the other
Yeah,
argument.
so how could we still rule for you if we reject the argument you just made?
Because the satellite transaction does not involve the United States government and is not part of the
I
FMS
thought
deal.
the United States had to approve it and did approve it.
The United States approves all sorts of commercial transactions.
I understand, but it exercised its sovereign power to approve it and did approve it, and it wouldn't have gone through without the approval of the United States, nor the approval of the Korean military.
That's true, but that does not take it out of the commercial activity.
I know it doesn't, because your argument is that every contract is commercial, and that's hard for me to think that Congress gave sovereigns immunity in our courts, even when the sovereign, except when the sovereign exercises some kind of commercial contract with involving the United States.
Well, I'm not treating the sovereigns any differently than the way the United States government as a sovereign is treated in our own courts. When it buys...
There's some contracts that are commercial, but there's some contracts that are sovereign, and one of the tests that helps distinguish is whether citizens in the commercial world, in the commercial markets, could engage in the same transaction. And clearly, the transactions we're talking about are inherently sovereign. It's taxpayer money went to develop these F-35s. They've been part of the national defense and national policy. We engage countries to participate. We sell only to those countries. We approve it, and it's all for the military defense of both countries. And it sounds to me like that is the conduct of a sovereign, not the conduct of a private citizen in a commercial market.
Judge Niemeyer, what I would submit is there's no case that analyzes a fact pattern using that analysis. The cases say, including cases involving military equipment, that it doesn't matter what the purpose is. In the legislative history to the Foreign Sovereign Immunities Act itself, it says a sales contract is commercial even if it's for military equipment and even if it's for a military purpose. Going to war is a sovereign act. Buying equipment to help you go to war is not. The only thing that's different from the existing case law, and there is existing case law that this court would have to depart from to rule in the way you are articulating your perspective. You would have to depart from how the the Ninth and 11th Circuit have ruled, how they favorably cited the virtual defense case, which involved the sale of MiG fighter jets that can fire nuclear weapons that Moldova was trying to sell to the United States as part of the end of the Cold War and giving its weapons away. That was sovereign activity, but the form of it was the sale of goods between two parties and two government parties. And the lawsuit was by a broker. That's virtual defense, Judge Urbina, 1999. No case has ever said, well, that was way out of line. Instead, they favorably cited it in both the 9th and the 11th. And so, Your Honor, I think this court would be departing from those precedents if it ruled that
What about if we entered into a treaty with South Korea where we agreed to share arms?
Yes,
And as part of that treaty, we sent F-35s to South Korea.
that might be different, but on that,
What makes it different?
well, first of all, I don't actually, if there was a contract for the acquisition, it might still fall under commercial activity.
Part of the treaty.
It's part of the treaty. I would like to refer the court on that question to the Mortimer case cited on page 34 of our briefs, where the government of Germany, West Germany, entered into a treaty with the United States after World War II and assumed the debts of the regional banks around Germany that were incurred during World War II. They were later sued by people who owned those debts, and they said, well, wait a minute. This isn't commercial activity. We did this under a treaty. You can't sue us for something we did under a treaty. Judge disagreed, said you're not immune, commercial activity. You owe money on a debt. So I just don't think it is as simple as saying you did it through a treaty or this is a product that only a government can buy. That is not how the...
What I'm getting at the bottom, if I understand your position, is that every transaction involving contracts, if a government acts tortiously in carrying out its own sovereign functions, for instance, protecting its borders, and it acts in negligence, then I suppose there's immunity. But if there is a contract for the sale of goods or services between two sovereigns, you're saying that is always commercial activity and the country's not immune. Is that it?
I'm saying what I'm really saying that I care to say most, Judge, is whether or not that's true or not.
Well, you want to separate the satellite
Well, but it is different.
and brokering the satellite and interference with the brokerage arrangement.
Yes, I do.
I understand that. That's another issue, but
that's the issue that matters. That's the only issue that matters.
But I don't, what makes it hard to analyze that is trying to find out the difference between sovereign immunity and commercial activity exempt from sovereign immunity.
Judge Niemeyer, nobody has ever argued in this case that the satellite that was being bought by DAPA from Lockheed could only be bought by a government. No one has ever argued that that satellite was something that the U.S. government was involved in. The U.S. government's...
They were involved in it. They approved it, didn't they? They had to approve
The
it.
Green Book that this court cited favorably in the BAE case says the U.S. government cannot be involved, cannot encourage an offset transaction, cannot be involved in it, cannot be a party to the contract, cannot use its funds, and it is disfavored. Look at footnote 5 of our reply brief.
So the purchase of the satellite was not part of the FMS process?
It depends what you mean by part of. It was, the purpose of it was to fulfill the offset obligation that South Korea imposed under the FMS deal. So the FMS deal is, you could say, a but-for cause of the satellite transaction. But that is not enough to take it out of commercial activity. Again, the legislative history to the FSIA says foreign aid, giving foreign aid, that's sovereign. But if you enter into a contract to acquire goods or services as part of giving foreign aid, that's commercial. Again, the case on page 34 of our briefs says just because the but-for cause is a treaty or is a sovereign act, that can lead to commercial activity. The case we cited in our 28J letter from the 11th Circuit involving the marine exploration says the same thing. There's a treaty between Florida and France, but then there's commercial activity implementing that treaty. Your Honors, DAPA had a contract. This court in Worldwide DeMille, page 406 of that opinion, said, or maybe it's 604, I apologize, said it takes only a single act, negotiating a contract or entering a contract, a single act, and you've got commercial activity. Here, DAPA entered into a contract with Lockheed, not the US government, to acquire that satellite directly from Lockheed. Lockheed was to deliver that here in the United States, launch it from the United States. Blenheim was named in that contract, paragraph 129 of our complaint. And Blenheim had its own contract with Lockheed's affiliate, LMOC, here in the United States, pursuant to which it was going to earn its commission and structure Project Archer. Then, the Tortious Act. DAPA pressured Lockheed with a threat of negative press, paragraph 134, to abandon Project Archer. It negotiated. DAPA negotiated directly with Lockheed to change the deal. Paragraph 182 of our complaint. They came to the United States, DAPA did, to negotiate directly with Lockheed to change the satellite contract so that it would be a direct procurement from Airbus France rather than this Project Archer multi-satellite deal that Blenheim had devised.
Can I ask you,
That's commercial activity.
do I understand your bottom line complaint to be a tortious interference claim?
Yes. And a conspiracy to commit that interference, yes.
Antitrust laws, right. Does that change? In other words, the lawsuit is not breach of the transaction. The lawsuit is that you are cut out by tortious activity.
That's correct, Judge Nemier.
Does that make a difference under the commercial?
No, I don't think it does, because the contracts were with these other entities, these affiliates, and Lockheed, the parent, and Airbus France, and Korea, DAPA in particular, conspired to interfere with those contracts and get rid of the financing transaction Blenheim had devised, even though it was better for Korea. And the tortious acts of interference were part of DAPA's commercial transaction with Lockheed to acquire the satellite. It negotiated an amendment to that contract, which was part of its tortious conduct here in the United States, and it agreed to give more value to Lockheed, $500 million more in offset credits to this U.S. company, $155 million more in cash to Lockheed to pay for the full price of the satellite, because Blenheim was going to get the satellite to DAPA for less than half its price. So those are the tortious conduct that DAPA engaged in to implement the conspiracy and to get rid of Project Archer. And those actions are commercial activity with a substantial contact in the United States. The only other thing you could find is if you think those tortious conducts and business torts in the legislative history, cited in the legislative history of the Foreign Sovereign Immunity Act, cited in the Zidane case, which we cite in our brief, says business torts are commercial activity. This case is about a business tort. And so it's commercial activity with substantial conduct, which triggers the first clause. But even if, like the district court, you think business torts cannot themselves be commercial, which I think is wrong, it's an act in connection with commercial activity with a direct effect in the United States. The direct effect meaning the payment of $155 million, the receipt of offset credits, the fact that no money was forthcoming from the United States to Blenheim, the fact that Blenheim's United States contract with LMOC was interfered with. Those are all direct effects under the third clause. Your Honors, I'm going to run out of time soon. I don't know if I'm into my...
You have.
Okay, then shall I would like to address the antitrust issue quickly, but I could do so on rebuttal. Very, very briefly, I just...
You were peppered with a few questions, so I'll give you a little time to do that. But
Thank you, Chief Judge Gregory. I'll be very brief. On the statute of limitations issue, the first thing to understand, we have two basic points. One is to implement this conspiracy to oust Blenheim and Project Archer, more was required than simply terminating the contract. One thing that should be clear from the complaint, this is a factually complex deal with multiple parties and constituencies, some of whom wanted to do the deal because they knew how good it was, some of whom didn't and tried to undermine it. So they had to not only terminate Blenheim, they had to get Korea to approve the new deal and to pay a lot more money to do the new deal in ways that were really not proper. And then they had to get the US government to approve it all, as Judge Niemeyer said. Those things did not happen until 2017 or later. And the complaint doesn't tell you when they happened because we don't fully know when they happened. So on the face of the complaint, you cannot dismiss this case, and it should not have been dismissed, for statute of limitations. And related to that, even on the termination itself, there's a factual dispute as to when it became effective. That can't be resolved at the motion to dismiss stage. And then quickly on FTAIA, I would just quickly say there's not a lot of case law in this area. I think it's a first impression essentially in this court, for this court. We have two co-conspirators, Airbus and Lockheed, that sell leasing capacity in X and KA bands. One of them, Airbus, we cite in our brief, says that one of its 5 biggest customers is the United States government. All of the customers are governments, and one of the 5 biggest for Airbus is the US government. It's a reasonable inference, since Lockheed's in the same business as we allege, and is right next to the US government. They're one of Lockheed's biggest customers too. And they wanted to make sure Blenheim didn't enter that market for satellite leasing X and KA bands, for which the US government is one of the biggest customers. And we allege that that was a customer for Blenheim, and we actually have a lot of facts beyond the complaint that would show they were the main customer. And under that scenario, where you are excluding someone from coming into a market where the US government is one of the biggest customers, and where one of the co-conspirators is a US company, that affects domestic commerce, that affects import commerce. That should be either in the import exclusion or the domestic effects exclusion. Thank you, Your Honors.
Thank you, Mr. Hume. Mr. Greenwald?
Mr. McLaughlin will go first, Your Honor.
Okay, all right.
Mr. McLaughlin's going to address the Foreign Sovereign Immunities Act.
Well, that's fine. It was just listed different, but it's fine. That's fine. Thank you, Counsel.
Our apologies, but good morning, and may it please the court. I'm Brian Tully McLaughlin. I represent Lockheed Martin, and as Mr. Greenwald said, he represents Airbus. We're going to share our time. So we have 2 questions of jurisdiction, excuse me, that bring us here today. The first, of course, being the Foreign Sovereign Immunities Act, which was the sole basis that that Blenheim pled for jurisdiction in its original complaint. Upon seeing our motions to dismiss, it quickly amended to add a new cause of action that would potentially provide another jurisdictional hook. That was the antitrust claim that Mr. Greenwald will address. But I think Judge Niemeyer's questions, Judge Thacker's questions were very apt in this situation.
We may be wrong in the direction that our questions were focused. If I understand the argument is that a contract for goods between, with a sovereign is the sovereign acting in a commercial capacity. In every case, even if it involves military goods that cannot be engaged in by the private sector.
Right.
I think that's the position that's being taken. Now, the lawsuit is actually a tortious claim. It's not a breach of contract claim, but I don't know if that makes a difference, but I'm interested in your argument.
Sure, it does. And let me address, I want to address the FMS. I'll do that briefly, but also the argument that's being stressed here, which is that the offset is somehow separate and that's the commercial activity. So I'll focus on commercial activity first, and exactly that question, Judge Niemeyer. So again, the definition, the statute doesn't give us a lot of help in terms of what commercial activity is. It does say that a single transaction could meet the test, but the Supreme Court itself has said, well, we really have to look at what's going on underneath. And it is the nature of the test, and we don't dispute that, but it has to be, as counsel said, it's the outward form of the action that's being engaged in. It has to be the type of action that a private party could engage in. And the level of generality here that's being forwarded by Blenheim is far more than that which is supported by that. So here we have—
Opposing counsel says that nobody has said in this litigation that a private party couldn't purchase a satellite. Separates the two.
Okay, so on the offset, I would say it's true that a private party might be able to purchase a satellite. South Korea could potentially go out and purchase a satellite, but that's not the nature of the transaction here. And so we have an attempt to distinguish that from the FMS transaction. Those things are inextricably intertwined, and here's why. When South Korea wants to purchase defense articles, it has to go to the government, and as your honors pointed out, here we have a foreign military sale, not a direct commercial sale. In a direct commercial sale, the defense articles could be purchased directly from Lockheed and from South Korea and Lockheed contracted together.
But a sovereign can engage in commercial activity that is not inherent in sovereignty, right?
It can.
Yeah.
But here,
So how do we, and I understand you're pointing out that it's the degree of specificity, the generality. What guiding principles do we use to determine whether it's sovereign or commercial?
the principle is whether the sovereign is exercising only a power that private parties could exercise. Here, that's not the case, because a foreign military sale, by definition, is limited to sovereigns as the contracting parties. And this was even more that case, because this had been designated as a transaction that could only be a foreign military sale. In other words, the transaction here could not have been alternatively a direct commercial sale. So only sovereigns could engage in it.
How does your definition square with square with Weltover's Supreme Court in Weltover, but said clearly the question is not whether the foreign government is acting with a profit motive or instead with the aim of fulfilling uniquely sovereign objectives. It says that that's not the test. How does that square with that language in Weltover?
It squares because they still have to look at what the nature of it is. And so I agree, the fact that
The nature of it is they're selling goods. It says right here, it's not whether their objective is uniquely sovereign objectives. That's the question. You're now talking about the sovereign objective, but Supreme Court clearly said in Weltover, no, that's not the test, whether that's the objective. The question is the nature of what it is. It's a commercial transaction. They're selling goods.
Sure, I'm not talking about the objective, Your Honor. I'm talking about the nature of it. The form here is a transaction that only sovereigns can enter into. And what makes that different is that even in Weltover, yes, there we had bonds. And what the Supreme Court looked at in Weltover was whether there was something about those bonds that made them other than garden variety debt instruments. That was the holding. And they looked and they looked and they didn't find anything. But they conducted the analysis. And that's the point here. Here we don't have a transaction that has any of the normal ties of a transaction that a private party could enter into. This one, again, is limited only to sovereigns.
A private party couldn't buy satellites?
If we go to the satellite, a private party could buy a satellite, but this type of transaction is not that. Here, a satellite is not being purchased. It's part of an offset to the foreign military sale. And an offset is something that a purchaser, the foreign sovereign, requires as a condition of entering into the foreign military sale. Blenheim, in its amended complaint, concedes that those things are intertwined. They go together. And we have paragraph after paragraph in the amended complaint, paragraphs 27, 28, 34, 35 that talk about that. But let me read you one other thing, because this is important. There's a lot of talk about the money and how that's exchanged. So the prime contractor is permitted to recover all costs for offsets from the U.S. government, which in turn bills the foreign purchaser. In other words, in the FMS context, all monetary transactions flow through the Pentagon. I just read you a quote from paragraph 46 of the amended complaint. That's in their complaint. So they recognize that all costs for this transaction, for the offset, for the satellite, go through the FMS. And the Green Book, which they cite, also recognizes that, albeit on pages that they did not point out. Pages 921 and 922, it says offset costs are actually included in the line item costing of the FMS purchase. In other words, South Korea can't go sue Lockheed about the purchase price or the cost for the offset. It has to go through the U.S. government if it has that kind of an issue. That makes this completely different from someone, whether it's South Korea or a private party, going out into the marketplace to say, we're going to buy a satellite transaction. So it's a completely different type of transaction. And again, the Supreme Court cases, if you look at them carefully, some of them lead to a finding of commercial activity, but it's not at that level of generality. I'd point out another case, UNC Lear, which was relied on by Blenheim. And in that case, there was a finding of some level of commercial activity, but that had to do with a transaction directly with a private company. But there was also a contract for services that was a contract for security services for head of state. And the court there said that is not a commercial activity. So it's, again, the level of generality the nature of the transaction and whether that is a sovereign one.
If the transaction did not include F-35s, but rather involved corn, and it was a set-off transaction where a satellite was provided in order to induce South Korea to buy corn. We had a surplus of corn. Would your argument be the same?
I would say that that might be different because I don't think we'd be talking about a foreign military sale. So if South Korea wants to buy some corn from, and it's going to do it from a private party, or perhaps it's going to do it from the U.S. government, that might be very different. That, of course, is not the case here. So it's.
What is your argument that anything that constitutes statutorily a foreign military sale is involves sovereignty of the country?
It does, and particularly in this case where by presidential direction, these defense articles were dictated that it had to be foreign military sale only. That is the only way that these articles could be sold, which is why this is a narrow case. This is not one where we're saying every type of transaction that involves two sovereigns is necessarily not commercial. And we recognize there was a case cited by counsel last night in their brief where a sovereign entered into a services contract with a state, Florida I think it was, that had to do with excavation, global marine excavation. Has nothing to do with something that it's not something that a private party couldn't transact for. Completely different. Here, there is no private party in the world that could enter a direct transaction with South Korea to sell these products. And again, the offset is not different from that. It's incorporated into the foreign military sale. So again, there's no privity of contract in that way between South Korea and Lockheed Martin, as there might be in a direct commercial sale, which this court actually discussed in the BAE case several years ago, although it wasn't reaching that issue, but it discussed the very different contours of a foreign military sale versus a commercial sale.
So does this turn on the objective of the sovereign, or just because it's military equipment?
It doesn't turn on the objective. That sounds more like what's the purpose of it. It turns on the question of, is this a type of action that is this action something that a private party could engage in? As the direct, could a private party sell these products to South Korea? Could South Korea obtain them from a private party directly? And that's the test there. You cannot remove the U.S. government from this.
Well, that's the test thing. Going back to Judge Nehemiah's corn and that hypothetical, if it was a point where corn was such, at the markets was such that became a strategic product internationally, and the government said, the United States said, look, nobody's going to be able to sell corn into a foreign market without our permission. And then there was a contract to sell corn to a foreign sovereign, then that would be included, right?
I think if we were in that context, it might be a difficult question, although I think here.
You said because, and a private party can't sell corn because that's what the government said. No, corn is such that it becomes strategic to our economic, stability, that we only do it.
Yeah, well, I think there's a little bit of another difference there, is that do we have that nowhere in the world private parties can sell each other corn? Can two people out on the street sell corn to each other? That's very different. Here we're talking about something that absolutely nowhere in the world and between no parties other than from the U.S. government can this type of product be sold. If we had that with corn, then I would say yes. It's not.
Because you said nowhere in the world could be sold. That's what you said. That's the test? Did you say that?
The question is whether a private party could sell the corn. So
and you said nowhere in the world what?
I believe I said that, are we talking about that nowhere in the world could private parties engage in a transaction related to corn?
Because you're saying that nowhere in the world could private parties engage in a transaction related to fighter jets.
Yes, Your Honor, thank you.
Okay, I think that's what I was understanding.
Yes, and I wanted to address the virtual case, the Moldova case. That's a very different transaction. It is between sovereigns, and again, we're not saying that it's a blanket rule that just because there's sovereigns involved that's the only thing that matters. It does matter though, and in that case, we didn't have an FMS transaction. We had a country, Moldova, who had hired an individual as an agent to try to sell their the MiGs that they had, and they wanted to sell it somewhere. They wanted to sell it to Iran. They wanted to sell it somewhere into the United States, maybe to a public party, maybe to a private party. That was the real focus of that case, but we didn't have any kind of limitation on to whom they could sell those. And again, that was...
Ask you this, there's something intangible that's gnawing at me, and I'm not sure it's appropriate. If I understand, and I don't know if the record shows this, the F-35s were developed by the United States and several other foreign nations who contributed financially to it. And that was limited as a matter of foreign policy. As a matter of fact, Turkey was part of that, and then we've excluded them from the program as a matter of foreign policy. Korea is part of that program and is one of the few countries that can get F-35s. This is what I understand from the public press, and I don't know if it's in the record or not. If the F-35 is an instrument of foreign policy, not only limited to military, but limited to particular countries, and there are only a few in the world, does that make a difference?
I think it does, and that is at the heart of, again, it's not the only thing we need, but that's very critical here. This transaction is subject to all kinds of foreign policy and presidential directives, and that's what makes it the type of transaction it is. That's why the government says this will only go through the U.S. government. No one else will be allowed to sell this for all the reasons that Your Honor just said.
Well, you go down that rabbit hole, then basically there's no limitation at all. I mean, foreign policy is involved in a lot of things. For example, dumping rice in other countries, excess rice in other countries. It's a question in terms of, you know, what policy we have in terms of impacting other countries' economies. Well, there's always some policy, foreign policy. I mean, that's, again, you're getting very far from Weltover's direct saying it's not about the objectives. This thing is just spanning down. There's policy involved and those type things, and which country it is, and maybe it was another country. But this is really commercial activity. It's commercial activity, and it seems to me that some of the cases you cited is different. This is not involving personnel and those type things, nor the active protection of the country and those things. We look at what the nature of it is. And the nature is commercial. And these are private companies. Lockheed is a private company, isn't it? Stockholders?
Yeah, yes, Your
Is that
Honor.
right? Right?
Lockheed's a private company.
Right. And Airbus is private?
They're private, but I think Your Honor is not looking at this transaction the right way. The transaction.
I'm not looking at what the right way?
The transaction, Your Honor, the sale here.
I'm asking you a question.
Yes, excuse me. I agree. Lockheed is a private company. I wanted to make a further point. I
Well, make your
apologize.
further point. I thought you would say, I'm not looking at something the right way. Go ahead.
What I wanted to say there, Your Honor, is that when the fact that Lockheed is a private company and that Airbus is a private company is not something that impacts the nature of this foreign military sale, because the sale is between the U.S. government and South Korea, and it cannot be otherwise.
Yeah, fair enough. That's correct. But you're still talking about the question, is it, but tell me this, what is your best case for your position in the Supreme Court case?
I think Weltover is just fine
You think so? All right, good. I'll make sure. So Weltover is your
for a Supreme Court case on commercial activity.
Okay.
But I would also say, if I may have just a moment to address the other points, I know that I'm over time. Even if there is commercial activity, we then need to go to a second fundamental question, and that is the suit, the gravamen of the suits, based upon that commercial activity? And the Sachs case, the Supreme Court's case in Sachs, is essential to our case, so very important case. And so Sachs says that you must look at the particular conduct that constitutes the gravamen of the suit, the acts that actually injured the plaintiff. And this court in France.com said that. So that is, it was made clear that activities that lead to the conduct that eventually injured the plaintiff, that doesn't qualify. So here, what is the basis of this suit? It is, as Your Honor pointed out, Judge Niemeyer, it's a tortious interference with contract suit. So the allegation is that South Korea, as well as Lockheed and Airbus, tortiously interfered with Blenheim's contracts with Lockheed and Airbus regarding the procurement of a military satellite and commercial satellites that Blenheim hoped to gain. That is the nature of the suit. So the fact that we have a foreign military sale and even an offset transaction as part of it with South Korea and the U.S. government, that may be along the road to their claims, but their claims are focused on the interference in their contracts with Lockheed and Airbus. So the basis of the suit is not the foreign military sale. Proof of the foreign military sale or proof of the offset transaction is not at the heart of their case. It's not going to prove their case. The proof is what was the interfering activity? And all of that activity occurred outside the U.S. And the JAMS, another important case, Supreme Court, JAMS said that when we're talking about tortious activity abroad, then it's not related to the commercial activity carried on in the United States. That's a fundamental principle here. So what was that activity? That activity is we have contracts with Blenheim, and it is a foreign company. It expects to get paid where it is, which is in the Channel Islands, not in the United States. When its contracts were terminated, that's the harm that they're talking about here. So they're proving that. That's something they didn't get paid. They got cut out of the deal. That occurs outside the United States, but it's not.
They're alleging conspiracy, aren't they?
They do.
And you say the conspiracy is cabin to foreign soil, as they're alleging?
The basis of the suit is tortious activity. And so proof.
Conspiracy is broader, isn't it? In other words, you're saying that conspiracy is cabin to foreign soil? Just because people signed the contract where they signed it? Conspiracy is pretty broad, isn't it?
I think what the point I'm trying to make, Your Honor, is that the conspiracy, tortious conduct has to do with Blenheim's contracts. It doesn't have to do with the offset agreements or the FMS deal. So focusing on the FMS, that's not the basis of their claims. The basis of their claims is that their contracts with Lockheed and Airbus were interfered with. And so that is separate from the commercial activity that we've been talking about for some time now. I'd also mention there was a point made about—
But the vehicle through which they were interfered with was this transaction, wasn't it? By getting them out of this transaction, as they're alleged, obviously, and the trial can determine differently, but as they're alleged, it said that this transaction was the vehicle which they used to do that. Like, we cut them out of this deal, they'll cut them off their knees, and they can't.
Well, and that's
be a player against us later. I mean, that's what they're alleging.
That's the point I'm trying to make, Your Honor, which is that what is this transaction? What Blenheim was cut out of was not the offset transaction. They're not a party to the offset transaction. They are not in there. The transaction they were cut out of was they had a contract with Lockheed Martin and they had a contract with Airbus. So their allegation is we were cut out of those contracts and we didn't get paid on them, and we didn't have an opportunity to get commercial satellites that we expected to gain from the contracts that we had with Airbus and Lockheed. This is not about the proof of whether the offset transaction that's part of the FMS that's not going to prove their claims here. I would also mention that there's this point about, and this really goes more to, is there a direct effect of that tortious activity in the United States? And this is my last point. And here, the cases circuit after circuit, and we pointed some of them out in our brief, but they look at what was where did the real harm occur? And what was that immediate impact? That's what Weltover said, by the way. They said a direct effect has to be an immediate consequence of the tortious conduct. And here, what is that direct effect? Well, it's quite obvious when you look at the amended complaint, it's just been presented differently on appeal. The direct effect is the fact that Blenheim was, as they say, cut out of their contracts. They were no longer getting paid. That is an immediate impact of the tortious activity that they are talking about. What they're focused on now is, well, we have a potential direct effect in the United States because we allege that South Korea was going to give additional offset credits to Lockheed Martin. First of all, I'd point out that their allegation on that, and it's paragraph 136 in the amended complaint, JA-101, the allegation is DAPA began discussions with Lockheed about providing an additional $500 million in offset credits if Lockheed restarted the military satellite project as a direct procurement. So as most they have is an assertion that there was a discussion. That's it. But I would also challenge that the idea of offset credits as a direct effect of being terminated from a contract with Airbus, being terminated from a contract with Lockheed. That's simply not a direct effect, and Weltover made that clear, and the other circuits have said it too. If we're trailing down the line and other intervening things are coming in, we're not in the direct effect land. The direct effect is that they were cut out of the deal. They didn't get the money they want. That's what they're seeking in this lawsuit. We want millions, hundreds of millions of dollars because that was the direct effect of this tortious activity. So that is not something that occurred in the United States. They're not a US company, they're a foreign one. So that effect occurred outside. And with that, if there's no further questions, I'll turn to my co-colleague.
All right, Mr. Greenwald.
Thank you, Your Honor. May it please the court. Thinking back to the procedural posture in this case was brought by Blenheim in the Eastern District of Virginia. Airbus, our client, is a French company. Lockheed is not a Virginia company, it's a Maryland company. Korea is obviously not a Virginia company. The reason that Blenheim pled, and the district court didn't even reach this because the district court found it didn't have subject matter jurisdiction, so it didn't even reach the personal jurisdiction arguments. But the nexus that they claim was the foreign military sale and the approval of the Pentagon. And that's why this case is about a sovereign act and a sovereign-to-sovereign transaction, including the offset transaction. They're saying we should be in Eastern District of Virginia because this case involves the Pentagon, but when it involves the Pentagon, it has to be a sovereign-to-sovereign act with Korea, including the sale of the military satellite. And the military satellite was paid for by Korea to the Pentagon, and the Pentagon gives the money to Lockheed. And if Korea gets a clunker of a satellite, which thankfully Airbus did not do a clunker, but a good satellite, but if there had been a clunker and Korea was unhappy, Korea couldn't sue Lockheed or Airbus. Korea could only go to the Pentagon. And if Korea didn't pay, Lockheed could only go to the Pentagon. This is not commercial activity. Only if corn were completely nationalized and farmers who wanted to export could sell to the Department of Agriculture, and then the Department of Agriculture sold overseas, then that would not be commercial activity either. So commercial activity here doesn't occur because the Pentagon is the intermediary in the offset transaction. The money flows through the Pentagon, and any claim.
The argument that even a commercial type of contract between two sovereigns is covered by the Immunity Act?
It depends on the nature of the contract, but if it's the kind of contract that only two sovereigns can enter into, like a foreign military sale, yes. But if it's a general commercial contract, if the state of Virginia's tourism office
What if we provide foreign aid to Ethiopia in kind? Our government goes into the commercial market in the United States, buys food supplies, and then ships them free to Ethiopia to help the people. Is that a transaction covered by immunity?
I didn't hear Ethiopia's involvement in that.
They donate the, say it's corn again, they donate the corn to Ethiopia for distribution to the people.
That does not sound like a commercial contract. That is a sovereign-to-sovereign action. And
Well, that's my question. If it's sovereign to sovereign, your position is that it's always under the act.
sovereign-to-sovereign of the kind that only sovereigns can do, which includes foreign policy donations, like the type Your Honor just described. If it involves general commercial activities that sovereigns also engage in, such as tourism or providing various services of their departments, that would be different. But a foreign military sale is an only sovereign activity, and the U.S. government says, we will decide which countries we're going to sell to, and we're not going to sell to people. We're not going to sell to companies. We're only going to sell to sovereigns. That's foreign military sales. And foreign military sales, FMS transactions, go through the Pentagon, which is why they brought this case in the Eastern District of Virginia, where none of the defendants are located, because of its nature as a foreign military sale in the Eastern District of Virginia, which includes where the satellite is paid for.
The lawsuit is a tort action. It's not breach of a commercial transaction. It's a tort action involving a commercial transaction, let's say. And the tort is committed by a foreign sovereign. Is that action subject to the act immunity?
Well, if we would have to look at the tort exception to the Foreign Sovereign Immunities Act. This is a tort action. That's the claim. It's
Well, I
a business
understand,
tort.
but I'm talking in generalities now. I'm just talking the scope of the immunity statute.
If the tort is related to a sovereign-to-sovereign foreign military sale transaction, then it is not based on a commercial transaction, and therefore the immunity is not
Your argument
waived.
is categorically, if the dealings are sovereign to sovereign, they're protected with immunity.
Of the type that only sovereigns can enter into, like a foreign military sale. Yes, Your Honor.
Well, sovereign to sovereign, nobody else can enter to sovereign. I don't care what it is, if it's a sovereign to sovereign, right?
Except when sovereigns offer services that they also offer, that they compete with private companies, such as, not in foreign military sales, but such as providing services like tourism services, that may be different. That sovereigns engage in purely commercial acts that are not the kinds of things only sovereigns can do, but foreign military sales are the kinds of things only sovereigns can do. In the United States and Korea, the United States said, we will choose which sovereigns, and only sovereigns can enter into this kind of transaction with us, the United States. And that's this case, that's this military satellite, and that's why this is not, there's no waiver of sovereign immunity, and they're out on that. And then I do want to turn to the antitrust claims. Paragraph 13 of the amended complaint says that this is their pleading, and the district court can look at their pleading and determine they haven't met the statute of limitations, says that the defendants cut Blenheim out of the deal in late 2016. Paragraph 146 of the amended complaint on Appendix 103 said that in October 2016, Lockheed gave Blenheim formal notice of immediate termination. In a refusal to deal case, when the plaintiff finds out that they're being refused to deal, they're not going to get the two commercial satellites, which is what they're complaining about. What they say the antitrust conspiracy, their cause of action accrued in October 2016 when they got formal notice of immediate termination. And nothing that happened after. Lockheed never said, oh, we'll reconsider. Now, Blenheim may have said, hey, we'd love you to reconsider, but that doesn't change their allegations. All the elements of an antitrust claim, an alleged antitrust claim, are met when they are cut out of the deal in 2016. They don't bring even their non-antitrust complaint until December 31st, 2020. They are outside the 4 years, and they're out of court. This court does not need to reach the FTAIA because the statute of limitations is clear from the face of the complaint, as the district court found, and that is enough to dismiss it, and therefore there's no subject matter jurisdiction based on that federal question. But if this court does reach the FTAIA, a poorly written statute, but there is no exception to this foreign deal that brings this conduct within, the alleged conduct within the Sherman Act. There are two exceptions to the FTAIA, conduct involving import trade, but the refusal to provide two commercial satellites built in France by a French company, delivered to an English company for them to enter the English satellite market, the satellites, that does not involve import trade, and the exception is not affecting import trade, it's involving. And there's no case where the refusal to provide foreign goods can meet the exception. And that the BioCAD case is clear that their intention to enter the US market is not enough to meet that exception. The other exception, the domestic effect, requires direct, substantial, and reasonably foreseeable effect on US commerce. Here, the number of steps, the proximate steps that they allege they needed to enter into, they were in negotiations with Malaysia. They didn't have a contract with Malaysia to use that orbital slot. They were in negotiations with a bank for financing. They were in negotiation with an unnamed provider to provide global coverage. And then they claimed they would have, after those negotiations happened, provided satellite coverage in a certain band that they say there's one reference to US agencies. They don't allege a market. We don't know anything about the interchangeability of the products or the elasticity of that particular market. We know nothing. And there is nothing in their complaint that pleads direct, substantial, and reasonably foreseeable domestic effects, and therefore they don't qualify under that exception either. I see I'm out of time, and unless the court has any questions, we'll rest on our briefs.
All right, thank you, Mr. Greenwald. Mr. Hume, you have time reserved.
Thank you, Chief Judge Gregory. On the Foreign Sovereign Immunity Act, counsel said there was no privity of contract between DAPA or South Korea and Lockheed. That's just plainly false. He may have misspoken. That's just plainly false. Paragraph 7 and 61 of our complaint talk about that contract. Paragraph 129 talks about how Blenheim was put into the contract as Lockheed's financial partner because Blenheim was doing the financing for that satellite acquisition. Paragraph 182 of our complaint talks about how DAPA came to the United States to amend that contract with Lockheed about the satellite acquisition to make it a direct procurement from Airbus rather than the Project Archer procurement with Blenheim, cutting Blenheim out of the deal, a tortious act taken in furtherance of the conspiracy to cut Blenheim from the deal. Second, the Foreign Sovereign Immunity issue does seem to come down to this question of the relationship of the offset to the FMS. The court believes that it is or likely or might be that the FMS transaction is sovereign. That doesn't anywhere near resolve the issue because this case is about tortious activity to interfere with a financing transaction that was supporting the offset transaction. It's 2 steps removed from the FMS transaction. Blenheim had devised a financing structure that was approved by the relevant parties to provide for the acquisition of the satellite that Lockheed would provide to Korea pursuant to a contract that was only between Korea and Lockheed, that was then itself connected to and designed to help further the FMS transaction. 2 steps removed. Further, the fact, whether you call it inextricably intertwined or connected to or designed to further, whatever it is, the relationship of the satellite transaction and the financing of that satellite transaction, which is really the issue, to a sovereign, what we will assume for purposes of argument was a sovereign act of the FMS, even if it's inextricably intertwined and done entirely to service that. The case law is crystal clear that that doesn't make the downstream related transaction non-commercial. 4 quick examples. Weltover. They issued bonodes as part of a political effort to manage a severe domestic crisis involving foreign exchange in Argentina. And they restructured it by presidential decree. And they got no consideration. And the Supreme Court said, we don't care. It's a bond. Maybe you didn't get consideration. You don't have to. It's still commercial. Maybe it was done to help with this crisis. We don't care. It's commercial. It's the outward form that matters. 2, virtual. Defendants have never argued that virtual was wrongly decided. It's government to government. It's the sale of MiG fighter jets. No private party can acquire that. Okay? MiG fighter jets that sell nuclear weapons. Here's what the facts were in the first paragraph of virtual. Following the dissolution of the Union of Soviet Socialist Republics, Moldova emerged as a sovereign nation facing severe economic turmoil. In an effort to bolster its weakening economy, Moldova arranged to sell to Iran several MiG-29 planes, which were capable of firing nuclear weapons. The United States of America strongly opposed this sale on grounds of international security, and in early 1997 requested that Moldova cancel the scheduled transfer to Iran. Moldova agreed to comply. That's sovereign activity of the highest order, Judge Niemeyer. That's the kind of thing that all your questions were focused on. And Judge Urbina said, yeah, but it's a sale of goods. And this broker was cut out of the deal. Sound familiar? That's what this case is. So that's commercial activity. They've never said it was wrongly decided. Never, including today. And the Ninth Circuit and 11th Circuit cited it favorably. This court should too. Third example, the Mortimer case, cited on page 34 of our brief. West Germany enters into a treaty with the United States, sovereign act. We assume the debt of all these banks. Okay, years later they're sued. Hey, you owe us money. What, we entered into a treaty, not commercial activity. Court says, no. You have a bond, that's the type of thing private parties do, you're liable. Fourth example, our 28J letter of the 11th Circuit in the marine exploration case. Sovereign to sovereign conduct on things that only sovereigns can do. That phrase you kept hearing from counsel. Sovereign to sovereign activity, only governments can do it. That's what happened in that marine exploration case. France was trying to exercise its patrimony laws to claim a 16th century military ship sunk in the territorial waters off Florida. Two sovereigns got together and made a deal as to who was going to get that ship. That's sovereign conduct. But then the company that was trying to do the exploration on a commercial basis says, well, wait a minute, I had prior rights. And you at least had, and they had tortious interference claims, they had unjust enrichment claims. Those were allowed to go forward, commercial activity. So the inextricably intertwined, and finally, it's really a little too simple to say it's inextricably intertwined without taking cognizance of what the United States Department of Defense itself says. In the Green Book, it says that an offset is discouraged by the United States. It is an international business arrangement. That's what the United States government calls the satellite transaction. An international business arrangement that is strictly between the purchaser, and the U.S. defense contractor. That's on page 4 of our reply brief.
Your complaint seems to suggest that this was involved the Department of Defense, that they approved it.
They approve only the costs.
Received the money, and that it was an integral, necessary part of the transaction to complete.
There's no question.
And so it seems to me that it became part of the foreign sales, a military sale, integrally involved in it. It would not have occurred but for that, and the United States was very much involved. I mean, your complaint makes those allegations.
Your Honor, our complaint doesn't make any allegations that are inconsistent with the Green Book, and the Green Book is
I didn't suggest that it did. What I'm suggesting is what I just related.
Yes, but I think I disagree, sorry, Judge Niemeyer. Our complaint alleged that it was connected to the FMS transaction. It was designed to further the FMS transaction. Its purpose, the whole purpose of the, well, not the whole purpose, but the purpose of the offset transaction was to further the FMS transaction and give Korea a satellite that it needed. But purpose isn't the issue.
Well, you can call it purpose. You can also call it structure. The structure of the transaction was the transfer of a military satellite and F-35s to Korea in exchange for money and to the United States, payable to the United States. And pursuant to not only a foreign military sale, but probably the most sensitive military type of development. I mean, the F-35, I think, is our most recent jet, isn't it? And
I assume it is. It's not more sensitive, in my view, than the MiG-29s and that can fire nuclear weapons, Your Honor, but...
well, who can fire weapons? That's not the issue. The issue is...
that's right, nor is the issue...
Essentially a sovereign conduct, but...
Your Honor, I'd like to address what counsel said about direct effects not being in the United States. There were lots of direct effects in the United States of this tortious conduct. The offset, the $500 million of offset, was provided to Lockheed. It benefited a United States company right here in the United States. The cash, the extra $155 million that Lockheed got from the revised deal, improperly, I might add, that's referenced in paragraph 84, that's paid to Lockheed here in the United States, a direct effect of the tortious conduct, itself part of the tortious conduct. The tortious conduct, we allege, interfered with the United States contract that LMOC, the Lockheed sub, had with our client. That's the contract that was interfered with. It's a contract entered into by a United States company that chooses Maryland law. The LMOC contract was interfered with. There was no money coming out of the United States to Blenheim. Remember, Weltover was a third clause exception case, a third exception case, and the only connection to the United States, the borrowers were foreign, and the lender, Argentina, was foreign. There were 5 places you could select for payment all around the world. After Argentina defaulted and through presidential decree said we're not paying on time, we're restructuring, the plaintiffs, presumably for litigation strategy reasons, said, oh, we don't accept your restructure, we're choosing New York for payment. And then they sued when Argentina didn't pay. That was the only connection to the United States. Supreme Court said that's a direct effect. We got lots more than that here, lots more. No money coming out of the US, interfering with the US contract, money coming into the US, all things that only happened because of the tortious conduct. And the Exxon case from Judge Maida has a great survey of the case law here and shows from that case law that the direct effect does not have to be a legally significant act. They keep focusing on, oh, but the injured party was Blenheim over in Guernsey or the UK. That doesn't matter. The statute doesn't say all the direct effects have to be in the United States, and it doesn't say the legally significant gravamen of the injury of the plaintiff. To the contrary, the case law says, don't look at injury. The Cruz Connections case from the DC Circuit explicitly says that. You don't look at where the injury was for the direct effects, just look at what the immediate direct effects were of the conduct. And here I've given you many that were in the United States. Quickly moving to antitrust, Your Honors, statute of limitations. Paragraph 13, counsel read, but he didn't read all of it. He talked about how there were terminations in 2016, yes, but he doesn't say that after that, the defendants worked in concert to further the conspiracy, worked in concert to secure necessary US government approvals to alter the offset transaction that Blenheim had designed, and then proceeded with the transaction without Blenheim in July 2020. That's what we alleged. We alleged it took a long time for them to do this, and there was every chance they would come back to us if it didn't work, if South Korea and the US government didn't approve the revised deal. And I do want to make clear, this is an antitrust claim we're talking about. It can't accrue until we've been blocked out of the market. And we can only be blocked out, we can only go to court and say we were excluded from the market if we know enough that to know that the deal we structured would have happened. And to know that, we had to know that Korea went through with the deal. We didn't know that until July 2020. There may have been facts earlier, but after 2017, where it all crystallized and was going to happen. So it's way after 2016 that the facts occurred, and it's not evident on the face of the complaint. We need discovery to know when all these pieces were put together. We didn't know until July 2020 that the deal would have happened, and we would have been able to enter that satellite leasing market if we hadn't been cut out. Very quickly on the FTAIA, I'll just go back. Counsel did not really address my point. You have two defendants who are in a market for selling satellite capacity. The customers in that market are only governments. It's highly secure. And one of the biggest customers, the record shows, is the US government. They wanted to exclude the plaintiff from that market. The plaintiff had plans to enter that US market. That cannot possibly be precluded under the FTAIA. Your Honors, if there are no more questions, I appreciate your time.
All right, thank you, Mr. Hume, and thank you all, counsel. We appreciate your being here. We can't come down and greet you as we would like to do in our normal fashion, but know very much that we appreciate your being here and your arguments. Be safe, take care. Thank you. You may proceed, Ms. Baldwin. You may proceed.
Good morning, Your Honors. May it please the Court, Melissa Baldwin on behalf of the appellant Aminta Smith. We are asking the Court to vacate Ms. Smith's convictions with instructions to enter a judgment of acquittal on counts 21 through 23 because the convictions aren't supported by substantial evidence, and to order a new trial on the counts 1 through 20 because of the district court's evidentiary error in admitting summary testimony. First, the government's minimal evidence of an ambiguous nature regarding Smith Tax and Insurance Group's business form and ownership required the jury to engage in impermissible speculation to reach the ultimate conclusion that her returns were false for not reporting Smith Tax and Insurance's gross receipts on a Schedule C. So here, this case is akin to Chief Judge Gregory's opinion in Bonner, where the government in that situation was relying on the jury to conclude from their forensic evidence that the predominant DNA profile allowed the jury to thus conclude that the defendant was the last person to wear the baseball cap involved in the robbery. And this court pointed out that not every articulable inference is proper. And indeed, the Second Circuit also drew this distinction, saying that not simply because something is within the realm of possibility is.
Didn't Ms. Smith herself tell the agent that she'd been the sole owner of the Touched by an Angel's tax service?
Yes, Your
Didn't she tell
Honor.
the agent? Okay.
But that's still, even taking that evidence in the light most favorable to the prosecution.
She was not telling the truth when she told the agent that she was the sole owner of that tax business?
We're not saying that. Even taking that evidence in the light most favorable still requires the jury to engage in impermissible speculation. They have to first infer that Ms. Smith's belief that Touched by Angels Tax Services was a sole proprietorship was in fact correct, and then second, also to infer that Touched by Angels Tax Services was indistinguishable and frozen in time with Touched by Angels Tax Services in 2009.
Well, her clients who also testified seemed to be of the impression that she was the owner and their tax preparer as well.
Sure, but
even though she didn't specifically tell them that.
right, but simply because a customer may believe someone is an owner is not enough to establish
Because
that.
she held herself out as in that manner.
So, well, I don't think the customers necessarily testified to that, and even taking that as it is, only 5 customers testified. The government was only able to.
How many does the government need?
Well, given the fact that in 2014 alone, there were over 300 returns submitted.
At some point, it would be cumulative. I'm sure you would be objecting if they had more than 15 as cumulative. So why is 5 not enough? 1 could be enough, right?
Well, no, we don't think 1 is
for a
enough.
particular count.
We don't think 1 is enough, but because simply the customer's belief someone is an owner is not sufficient to find a return as false as a matter of law. As the government's own witnesses testified to in JA 78 and 102, a business, if it took a different form, if it had more than 1 employee, if it was a shareholder, partnership, it would have reported its income on a different form. And in fact, the IRS agent, records custodian admitted they never even bothered to search to see if Smith Tax and Insurance reported its gross receipts in another form, and it could be sitting.
Could the jury have taken the transactions from Santa Barbara, that Santa Barbara service, take 2015, there was about $130,000 transmitted to her bank account. She opened it up in the name of the service, but she was the only authorized signator. And then she took money from that for her own services and put it in some personal bank accounts. And the only money going out of that bank account to Benjamin was 1 payment for employment, which on the check noted that she approved it. Could the jury infer that all that money was her money then? I mean, she used it, she received it, she put it in her own bank accounts. She approved any other purchaser. She was the only signator on the bank account of the tax service.
Well, Judge Niemeyer, I think there are 2 problems with that analysis. And
Well, I'm not saying it's conclusive. I'm asking, could the jury conclude that? It seems to me, it looks like she is the owner. She runs the whole shop, and she got all the money, and she used the money at her own discretion.
well, if someone other than Ms. Aminta Smith received income, then the omission of a Schedule C, is true as a matter of law. And that's, the Ninth Circuit in the Landum case, and I think the government conceded this in its briefing in the Sixth Circuit Williams case. And so the fact that there was evidence that Benjamin Smith received.
1 check to Benjamin Smith in a minor amount, $2,000 or something out of $130,000. And all the rest she managed, she used, she put in her own accounts, and they weren't put on her tax return. And the question is, quite apart from that, the question is, was she observing corporate form? But we're not talking about absolute proof or conclusive. We're talking about, was there enough for a jury to infer that she received income on which she didn't pay taxes?
Well, Judge Niemeyer, here, the inference goes to the existence of an element. The falsity of the return is an element. So it's not enough for the jury to maybe be able to infer, there has to be sufficient evidence for them to conclude beyond a reasonable doubt. It's not enough that Ms. Smith is probably guilty or her return is probably false. It has to be false beyond a reasonable doubt. And so going back to, and so Judge Niemeyer, I think this might help you in what you're getting at here. And, the government, as you pointed out, there was a substantial amount of money going from the bank account to Ms. Aminta Smith's personal account. Now, the government failed to charge Ms. Aminta Smith with underreporting her total income for 2015, which was the only year the government submitted bank records for. So had the government charged Ms. Aminta Smith?
The generalization doesn't exclude all the evidence. In the prior years, there were different tax corporate forms or business forms. She kept changing the name. She started out with tax service, then it went to accounting service, then it went to tax and insurance, that type of thing. But my point is, I was just taking that as 1 year in which it's pretty clear she was running the show, and she brought all that income in, and she tried to shelter it under various, I don't know what her thinking was, but clearly the government was deprived of taxes, it seemed to me. At least that's what the jury concluded.
Well, right, but our argument doesn't depend on the fact of whether or not the IRS was deprived of taxes. It counts on whether or not the government charged the allegation it made in the indictment, which was that the omission of a Schedule C that requires reporting a sole proprietorship was false.
Right, she wasn't charged with under reporting income, was she?
Well, she was only charged with, she wasn't charged with underreporting her total income for 2015, which was the only year the government submitted bank records for. She was charged with underreporting her total income for 2013 and 2014, but there is no bank records for those years. The only evidence of her income that year corresponds with her employee wages from Smith Tax and Insurance, which were duly reported on those returns. So I would like to switch over now to the summary evidence question. And here, the government's admission on this appeal that they used Agent Archie's summary testimony as substantive independent evidence of guilt renders the evidentiary admission erroneous under this court's precedent in Olade. In that case, they found that the government submitting bank records that were not objectively accurate, but instead subjectively showed the government's theory underlying the bank records in that case, rendered it a 611A summary. And 611A summaries are admitted only to help the jury determine the truth in a complex case.
What about the fact that appellant offered a curative instruction, a limited instruction as a cure to any objection appellant may have had, did not object to the demonstrative exhibit that the witness used, and then also did not object to the general jury instruction about summary evidence and how it's to be used?
Well, the defense did object to the summary evidence.
And then before the court could rule on that objection, the defense itself offered a cure by way of limiting objection,
Well,
to
Judge
which
Thack-
it then did not object.
Judge Thacker, we disagree. The court had made a definitive ruling at that point. Judge Cogburn said that this evidence is fine, I don't see it going, and it was only at that point when Judge Cogburn was allowing the summary witness to go on and telling them, keep doing what you're doing, that we offered a limiting instruction.
What JA should I look to for that?
So I think it was, JA 271.
I don't want to slow you up. Go ahead,
Sorry,
I'll
so
find it.
yes, and so once Judge Cogburn had made a definitive ruling under Rule of Evidence 103B, once the court makes a definitive ruling, they do not have to thereafter renew their objection. And so once it was in, it was in. And the problem here is, we offered the curative instruction, which, was insufficient upon reflection. But nonetheless, this isn't a case of invited error, because here the error wasn't from the defense. The defense was trying to cure it. And so here the error came about from the government offering summary testimony that wasn't admissible.
But then you didn't object to the final set of jury instructions about this summary witness?
We did not.
So you said in retrospect the limiting instruction wasn't enough, but then there was also the opportunity at the close of the trial when the jury was instructed to try to correct what you thought was not enough, but appellant didn't object to those jury instructions either.
No, we did not, but no, we did not, but we're not making a jury instruction error here. The error we're claiming on appeal is the admissibility determination itself, which we did object to.
Your position is that you preserved by making the objection, right?
Yes.
And the court had ruled and you preserve it, and then the other part, as you admittedly, I think, quite, I guess, forthcoming, that may not have been the best offer secure, but you're trying to do some damage control then.
Correct, we were, and I think part of this comes. I'm sorry.
Go ahead.
I think part of this comes from some confusion over these summary testimonies and evidence and how they get in here. And so the government pointed to Rule 1006. And under Rule 1006, those summaries are independent evidence of guilt. And so there's a suggestion that any summary can be both a 1006 and a Rule 611A. And that's just a false dichotomy.
I did find the transcript. The court didn't just say what she's doing is fine. The court said, I think most of what you're doing is fine. I don't have any problem with it. But then went on to say that there's a couple times she is getting over the line and started to tell the government how best to do it when the appellant counsel jumped in and said, I think this might be cured if we get a limiting instruction. So I did look at what you pointed me to, and I don't think the court ruled before the limiting instruction was offered.
Okay, well.
And we can disagree, but I don't read it that way.
Okay, so I guess we disagree on that point.
But did you object when she was first offered?
Yes, so we objected when she was first offered, and so I guess what Judge Thacker is getting at is when a defendant offers a curative instruction that is not in fact curative, does that thereafter waive the evidentiary objection that was made? And, I don't think that is, and just going off the fact, we want the parties to try and cure errors in the trial court, and we want them to make objections, and we want them to help the district court on these hard evidentiary errors. This was all off the cuff. This was not, an
If you look at the testimony, early on you objected, and that testimony seemed to be all right under the 611 standards. The expert was trying to help the jury understand what the significance of the evidence was. There was a lot of evidence being pulled together. There were several times there were questions that I believe pretty clearly overstepped the right type of testimony, giving opinions as to the overall conclusion. And I think that was what the district judge was referring to. And so I think to generalize about the witness is not useful. I think we'd have to take question by question and look which ones are okay and which are not, and then determine whether they're harmful. I think the court's curative instruction was intended to cabin in those. There were about 3 or 4 of them that were quite questionable, to cabin in those. But the majority of the questions, it seemed to me, were just normal 611 type questions that seemed to fall within the heartland of what's permissible. This was not a 1006 type situation. 1006, as you know, is a summary of documents when they're too voluminous, documents that are in evidence.
Yes, Judge Niemeyer. So two responses to that. And first is that while we acknowledge summarizing oral testimony in a complex case could fall under Rule 611A, we disagree that Rule 611A covered this here. I mean, if you look at it, at page 256 is the taxpayer testifying.
Give a particular question, because there are, I would think, most of the early questions, the witness was well within the heartland, you weren't objecting also. You made an initial objection, but as the questions went on, it then progressed, and I think rightly there were points where questions were asked that pulled some testimony from the witness that she should not have been giving. And I think you objected, or the court made observations, said, yeah, there was some over the line, and issued the curative instruction. But even without the curative instruction, if we look at question by question, I think you're addressing, your argument has to be focused on a small percentage of the overall questions that the witness was given. But it seems to me if you press the argument, you ought a particular question and see whether the court made an error, whether there's an objection made the error. Because not all of them were, clearly not all of them were objectionable.
So I see my time has expired, but may I respond to your question? Okay, and so, well, what happened here, I understand question by question, but first of all, we don't believe there is anything requiring that, where our initial objection at JA 270
No, it's just a question,
covered.
how do we know what to rule on? I mean,
Oh.
the testimony as a whole was not erroneous, and a lot of the questions weren't. So if we're going to rule on your appeal, we ought to be getting a question here and there, and then determine, number one, was it improper? And my guess is you're going to be able to make that case, that some were improper. Right. And then the next question is, okay, was that harmful? And next question is, did the instruction cure it?
I'm sorry, Your Honor, I misunderstood your question. Yeah. So is it still all right if I answer it? I'm over. Okay, so we think it was erroneous because this wasn't a complex case where Rule 611A was necessary. But that said, we think the cleanest way for the court to resolve this is to go to the witness's testimony. I believe it was at 281, where she is asked about the demonstrative exhibit 145. And there, the summary witness went beyond the evidence to drawing her own inference that not only did Smith Tax and Insurance receive $300,000 in gross receipts, but those gross receipts went to Ms. Aminta Smith. Now that ties back into the insufficiency question. And then they relied on that in their in their closing argument for the jury to find willfulness on counts 1 through 20. So we believe that question right there was absolutely erroneous, and it violates.
What aspect was that the money went to her?
Yes. So
there's just numerous documents in there of her withdrawing from these accounts with her initials on them. It's pages of it.
I mean, Judge Niemeyer, with due respect, there are only evidence of some payments in 2015, and her testimony went to years 2013, 2014, and 2015.
And was there any testimony about income other than 2015 from a fact witness?
No, for 2015 was the only one with bank records, and then to the extent there is any other evidence, it's her employee wages that were reported on her personal returns.
Right, so then the summary witness was allowed to testify that this $300,000, and no fact witness supported that, other than the part for 2015.
I mean, precisely, Chief Judge Gregory, and I think, and this is something the government does routinely in tax prosecutions. They have their IRS agent go through the bank records and show the unreported income, or, they do in the Williams case, and they show that the reported income doesn't match up with the lifestyle. You can't make $30,000 and have $1 million house.
This was not a net worth case.
No.
And this was not an expert. She was supposed to tell the jury what they heard.
Precisely. And so this case really is a good example of how summary evidence can be abused. And this notion that it's appropriate simply because it's a white-collar case is wrong, and it's what got the government into trouble in this situation. So if there are no further questions, I will reserve the rest of my time.
Thank you, Ms. Baldwin.
Thank you.
Ms. Ray?
May it please the court, Amy Ray for the United States. I'll begin with where the court ended and the question about the summary evidence, and I want to walk through just a minute exactly what was asked, what kind of testimony, and what was objected to, because I think that's
I would like to
important.
start with, beyond 2015, what was the evidence of the income underreporting supported that charge?
Well, every single one of the fact witnesses, every single one of the clients who testified, all 5, said that they paid Ms. Smith.
Because she worked on that when they were there, she worked on their tax returns.
That's right, Your
That
Honor.
sounds like an employee or worker.
Well, except for the fact that she was touched by angels. She was also Smith Insurance and Tax and Insurance Group. In the very first application that she made to
They
the...
testified to that, those 5 people?
No, but but if I
I just
may,
want to
Your Honor,
make sure that the people who testified, those 5 people,
Yeah.
they testified that we went there, she worked on their taxes.
That's right.
Period.
That's right.
All right.
And they knew her business from the beginning of, from 2011 until 2014, those were the tax years, so 2012 to 2015, when they saw her, they always understood that she was touched by angels. But I want to highlight a piece of evidence that I don't think we highlighted in our brief on that point, which is Joint Appendix 60 to 61, 1467 to 69. The very first time that she applied for an EFIN, which she did not get because they determined that she was unsuitable, she listed Smith Tax and Insurance Business Group that she was doing business as 2 ways. This was back in 2010. She was doing business as Touched by Angels, and she was doing business as Smith Tax and Insurance Group. From the very beginning, she identified herself as doing business as those 2 entities. And that carries through all along. So the evidence that we
Carried
have...
through, you're taking a form that was a request for identification in 2010 and saying, well, that carried on. Where's that evidence?
The evidence is that from the very beginning, she was this company. There is no evidence of any other...
Is that what she told the agent?
She told the agent, thank you, Judge Thacker, that she was the sole proprietor of Touched by Angels from 2009. That's what she said. Since 2009, I've been the sole owner.
Okay, so what's the...
So
Go ahead.
then we can connect Touched by Angels to Smith Tax and Insurance Group through a couple of ways, because that's the entity that we're talking about in 2013 to 2015, where there was no reporting of income received by that group. And it began then when she said, I'm doing business, she said this to the IRS, as Touched by Angels and Smith Tax and Insurance Group, during a time period in which she confessed and admitted to the IRS agent that she was the sole owner. We go through all along. The jury can draw the inference that this business never changed. It was always Aminta Ashley Smith. And she was the only one anybody ever dealt with. They saw a man. We know that there was at least one salary payment to somebody named Ben Smith that she authorized. And from all the way through, we know that Santa Barbara is depositing $90,000, $100,000 a year into an account that she controls. And she said in 2010 she was doing business as that entity. So the jury could infer from all of that there was one person who owned this one tax business, and that when she did not report in 2013 and 2014 that she was operating a business that had gross receipts, she didn't report that. And when she didn't report any income from that business that she had underreported, that the jury could infer that. The jury could also infer, of course, for 2015, when we do have the bank records, that she underreported her income. So that the jury, it's not a question of whether or not there is every single piece of bank evidence that we could have submitted. We did. We didn't need to. The jury could infer from the beginning. Now, I do want to just quickly go to the summary. I want to kind of get back to what I was starting with, and this is the reason. I don't think our brief did a great job of setting out what testimony was offered when and what was objected to. The first thing that happens when Agent Archie testifies is she talks about did you hear testimony that Galloway didn't work for Jack in the Box? Yes. Okay, so she's referring to testimony that had been given. But then she goes to the IRP data. Now that IRP data, if your honors will look in the exhibit, it's extensive and it's not easy to understand. And so what she said is, if you look at the data, Jack in the Box never filed a W-2 for Mr. Galloway. So she is referring briefly to a witness's testimony, but then she's bringing in something that the jury could not have easily understood on its own and explained why that's relevant. She does that for 2 witnesses, and then the defendant objects. And the defendant objects and says simply, this isn't fair because she's referring to a witness's testimony. She's not allowed to summarize what a witness said. And she had been very careful about that. Okay, and she says, plus we think it's getting into the ultimate fact. Now, the ultimate fact that they said was what she testified to. If this information was false, then it would affect the ability for the IRS to properly calculate taxes. She didn't, that was if it was false, then it would. She didn't say it was. She didn't say it did. Now, they object. Okay, they objected to that testimony.
This person wasn't an expert.
No, she's not represented as an expert.
Right, so she's not allowed to give an opinion.
She is allowed to say, I think.
Not an opinion.
They didn't object on that basis, Your Honor. So they object to that testimony. Then they say, hey, how about this limiting instruction? The judge gives it. That is it for the objections. They never objected to the summary charts. They never even objected when they asked her, did Ms. Smith receive income?
So they never objected again after the limited instruction?
Nope.
Did they ask for a continuing objection?
Nope. Not only that, but the very next thing.
Is that required to have a continuing objection? You make objection to this witness testimony? That's not required.
Your Honor, they didn't object generally to Ms. Archie's testimony. They didn't object generally to her. In fact, they knew all along. She was in the courtroom the whole time. They consented to her testimony. They consented to those charts they're now objecting to on appeal. They said, we have no objection, and they were admitted as demonstrative evidence. And
So we have to review that on plain error.
absolutely, yes,
And this, okay, all right.
yes. Okay, and so those, if Your Honor wants me to turn to whether or not that's appropriate testimony, or appropriate evidence, summary evidence, we look at Rule 611. And I would respectfully suggest that the evidence of the Santa Barbara records, which, Your Honor, are from page 1570 to 98 in the joint appendix, do beg for a chart. They're not that easy to see. And so that chart that had the kind of comparison, I reported no income and here's how much Santa Barbara transferred to Smith Tax and Insurance Group, that's a completely appropriate summary chart. Then, in terms of the earned income...
Did she object to the chart?
No, not at all.
Well,
In fact, she...
Is she objecting on appeal to that chart?
Well, I think so. I mean, that was the only...
It's unclear to me because my dialogue, and I don't want to be critical, but my dialogue essentially with your colleague is that it's much more helpful to focus on a question and an answer and then see whether that was material and affected it. My take on this is that the court responded to the objection and gave that instruction that they requested, and that seemed to satisfy them.
And it was, that's right, Your Honor, which is why I sort of wanted to kind of walk the court through, and I with all respect, appreciate that we didn't walk the court through that as carefully as we should have in our brief. But there was one limited objection to her testimony, which was that she was restating, witness testimony. She never did it again. If you notice,
and that she was getting to the ultimate issue.
Thank you. Yes, Your Honor.
Two objections.
That's right. 2 objections, but within.
But in one sentence.
In one discrete type part of Ms. Archie's testimony. And if you notice, the very next witness, she doesn't summarize. She doesn't summarize what that next witness. She's talking about LaToya Johnson. I
You
believe.
mean Ms. Ritchie doesn't summarize?
That's
She
right. Ms.
stopped.
Archie doesn't summarize.
Archie, I'm sorry.
She goes straight to the IRP data. She goes straight to, was there any information in the IRP data that supported that she worked, I can't remember if it's she worked for, I have it here, but anyway, I can't remember, but she doesn't say, did so-and-so testify to this? She stopped that completely after the defendant objected to it. And the defendant never again objected. As I understand it, Judge Niemeyer, the one sort of piece of evidence that I hear defendant objecting to was one question which was asked on page 280 of the joint appendix, which was essentially, was there evidence that Ms. Smith received payments, received income from all of this? And she says yes. And so the complaint is, well, that goes to the ultimate issue.
You mean appellant is objecting to it now on
Now.
appeal?
Did not
Appellant
object
did
then.
not object, I'm looking at that. Appellant did not object at trial.
Absolutely not.
So the
Thank you.
court was
Yes.
left to think the limited instruction was fine.
That's right. And well, and again, I mean, yes, I'll just say yes. But I'm sort of addressing Judge Niemeyer's question of what's objectionable, what do they think is objectionable on appeal? The one piece of evidence I think that they're especially objecting to is on page 280, to which they did not object at trial. But the one thing I want to note about that is that given the testimony of the witnesses, that yeah, I gave her money. I mean, that was, the idea was, this is who I paid. I don't think, one, that without an objection, that the district court acted arbitrarily or capriciously in failing to strike it, right? I mean, that ultimately comes down to, what is this court's standard of review? It's plain error under Rule 103, Rule of Evidence 103E. And so did the district court plainly and obviously err in failing to strike one question about whether or not Ms. Smith received income? And the answer is no, it wasn't plain and obvious. Nobody objected to it, and several witnesses had testified, yeah, she got my money. So the other point I would make on it all is it's harmless, even if there were error, and it certainly doesn't affect her substantial rights under the plain error standard of review, because this jury heard a lot of evidence that she was this business. And they heard evidence that there was more than $100,000 transferred into an account that she owned for the tax preparation fees, and that she then transferred on the day she found out about the search warrant. What happens? She transfers at least $25,000. 2 transfers, 1 check to herself from that business. Who owns that business? Who is that business? Ms. Smith. She said so, and the jury could reasonably infer that. I'll address briefly the adequacy of the explanation on the supervised release conditions.
Yes, particularly the drug condition.
Sure. Okay, Your Honor. So the drug condition was you have to request permission before you knowingly go somewhere where someone is selling drugs. And the only objection on that was really vagueness. So although the defendant challenged the drug testing condition on the basis that she had never been a drug user, the court sustained that.
The court didn't impose the drug testing because she wasn't a drug user. So what was the sufficient explanation then for imposing this other one?
Right, so I just want to make one thing, because this was something I wasn't really clear about until I went through everything in preparation for oral argument. When you then go from the drug testing to this don't go where you know drugs are being sold, that entire objection has to do with vagueness. So he says, well, particularly as applied to her, who she's not a drug user, it's vague, it's vague generally. The district court just said, Fourth Circuit hasn't held that it's vague. And I think that addresses it. This is a legal issue. It's not
A legal issue, I mean, in that sense, just categorically legal. The question is supposed to be individualized sentencing. And that's a part of the sentence, correct?
It is. And
So what is individualized about drug as to her? Anything in this record?
oh, no, absolutely not. She's
So
not.
then why would you put that there? What is it about her that make you tag her with this?
Your Honor, she hasn't challenged the application of that condition to her. She's only challenged the adequacy of the explanation.
But that's the
So-
same thing.
No,
The
Your Honor,
explanation is based upon, tell me why you're imposing that on me.
Right, well, she's a felon, and she's a convicted felon, and he says,
A whole lot of people are convicted felons, they don't put that in there, do they?
I think actually they do regularly put that in there, but
For everybody? Is that?
I don't know the answer to that.
I mean, but you at the Western District of North Carolina? I mean,
Yeah,
do they all do that routinely?
I think it is routinely, but I don't want to say. It's not in the record and I don't know. So I have seen it, but I'm not, actually, my colleague Anthony Enright has handled most of these
Drug
supervised release.
testing is also routinely put in as a supervised release condition. It wasn't for her here because she wasn't a drug user.
Right.
I don't understand, and the court, for me, did not adequately explain why the difference here, why this condition is imposed.
So
Considering, as Chief Judge Gregory says, it's supposed to be individualized sentencing.
it is, but the adequacy of the explanation does go to the objection that she raises. She only raised one objection. She only had one complaint about it. She didn't say, she said, it's vague. That's it. We can't, the district court doesn't have to respond to arguments defendants don't make. And they're not arguing on appeal that it shouldn't have been applied. They're arguing on appeal that the explanation was inadequate. The only thing they argued was vagueness, and he responded to vagueness. I don't think there's, and let's just go back to Chavez Mesa. What does the Supreme Court say has to be enough? It is as long as this court can conduct an adequate appellate review. The adequate appellate review is, did he adequately explain and why it wasn't vague? And he responded to that question. It was a legal issue, and he said if the Fourth Circuit holds that it's
Something about it only applies knowingly. You have to know.
yes, yeah, he did say that.
Which limits it.
That's right, and there was, and thank you, Judge Niemeyer, I should have mentioned that. There was a hypothetical that that her lawyer offered. Well, if I go to a park, and we all know that parks, and he said that's not it, because it has to be knowingly, and sort of said something to the effect of, I want to see the government bring that one. But I think that a district judge does not have the obligation to create arguments on behalf of the defendant and then respond to them. The district judge has to respond to the arguments that are made, and the district judge did that here. So I think it was adequate in that sense. If Ms. Smith was appealing as a substantive matter whether or not this condition was reasonably related and no greater intrusion than necessary, that's a different conversation that she's not presenting on appeal. If she were, we would be addressing it. She's not presenting that issue. She's saying, you didn't tell me.
Didn't the guidelines remove this condition in 2016?
I think so, but I don't,
And
again.
when was she sentenced?
She was sentenced in 2000.
After 2016.
Oh, yeah, sure.
So,
But this court's decision in Comer makes clear that a court there's no problem with imposing a condition that is not in the guidelines. That's fine. The guidelines, the conditions have to be consistent with the policy statements, but there's no problem with doing that. And she didn't make that argument in terms of you can't do that. Now, that might go to the other condition, which was that she seek permission.
Credit.
And she said, the policy statement says I really should only have to do this if I'm not in compliance with a repayment schedule. I shouldn't have to ask permission to extend credit. And he responded to that and said, no, given the amount of, over $171,000 of restitution, it's a short tenure of supervised release. It's only 1 year. And that brings me to this court's decision in Boyd. In Boyd, of course, this court made clear that the adequacy of the explanation is also how much a court has to say also goes to how onerous is the condition and how long. This is 1 year. 1 year, and it's a question of does she have to ask permission to get credit, or can she knowingly go somewhere where she knows that drugs are being sold? I would respectfully suggest that he did respond to those issues, and he responded to them adequately, particularly if we consider how much a judge has to say, depending on how difficult those conditions are and how long they're going to be imposed. But I think the more important point is it's not up to the district judge to make the arguments. It's up to the defendant, and the district court in this case did respond to those arguments.
No, it's up to the district court to give an adequate explanation for the sentence imposed.
That's right.
So you're saying that if the judge hypothetically makes imposes a condition that is totally disconnected, if there was no specific objection then if there's an appeal, we can't look at whether or not it was adequate because they didn't question it there?
I mean, I wouldn't,
You understand my hypo?
I do, Your Honor, and I see that my time is up. May I answer your question?
Yes, you may.
Chief Judge Gregory. I think my answer to your question is this: if they don't challenge the imposition of that condition, and they're only challenging the adequacy of the explanation, then this court just has to ask, is there enough for us to conduct appellate review? And if there is, and what this court has said over and over again in terms of explanation is, yeah, it has to be individualized. He went through a bunch of conditions. He was clearly responding to her individual circumstances. At every, he was responding. On that one, she only argued vagueness, and he didn't explain it further than that, except to say, he did ask the probation office. They talked about it briefly. That was it. I think that was enough because the court made clear that he knew this defendant. He was considering this defendant. He knew what she was charged with, what she had been convicted with, how much restitution she paid. I think it's adequate for this appellate review, particularly in this appeal, when she argued vagueness and it's a legal issue. And she's not challenging the imposition of that as a matter of whether it should have been imposed. I think that had she argued that, we'd be in a different posture. Your Honors, if there are no further questions, the United States respectfully requests that this court affirm the judgment of the district court.
Thank you, Ms. Ray.
Thank you.
Just one last technical thing.
Sure.
It does need to go back to correct the restitution.
Yeah, absolutely.
Wait,
Yeah.
and I don't think she did only respond to vagueness, because she says, and it's right after the discussion about why drug testing shouldn't apply to her. She says, certainly is applied to her since there's not much risk, again with drugs, but as a general proposition. And then she says that it's unconstitutional. And that's not the only objection. It's also because she doesn't have a history of drug use.
So, Your Honor, the way I read that statement, that assertion was as applied to her vagueness, right? So it's all a complaint about vagueness, because we can have an as applied challenge and we can have a general challenge.
She says, I think part of the issue here is unconstitutional vagueness. But before that, she talks about her not being involved in drugs, and that's why the drug testing wasn't imposed.
Right. I read that, and I read it a bunch of times. And my reading of it, and really, honestly, I was trying to figure out what he meant.
Ms. Baldwin and I disagreed on a reading. You and I can disagree on a reading.
I read that as part of one vagueness objection, and she said particularly as applied. And I would also suggest that the main thrust, the main thesis of the objection to that particular condition was vagueness. And as long as the district court responds to the main thesis of the defendant's argument, that's enough. Thank you, Your Honors. I appreciate your time.
Thank you, Ms. Ray. Ms. Baldwin.
Thank you, Your Honors. I'll start with the insufficiency argument. So again, it's not enough that the jury could infer. Actual falsity is an element of a 17061 conviction. They had to infer beyond a reasonable doubt that her tax returns were false for not reporting Schedule C income. And look at what the government has pointed to. They pointed to an admission from an IRS agent.
My question to you wasn't, it goes to the standard. In other words, once you have a verdict of the jury, then our determination is, did the jury have sufficient evidence from which it could conclude beyond a reasonable doubt that she was guilty? And so we look at the evidence most favorable to the government in that type of review and determine whether the jury could have, in that circumstance, reached the conclusion. I didn't want to misconstrue it, have it misconstrued.
Right. So, I mean, every element has to be supported by evidence from which. So that's all I'm saying. And so here, for the falsity, there is an admission to an IRS agent, and the IRS agent at JA 197 said, "I have no idea what Smith Tax and Insurance is." So the government wants to rest a conviction for not reporting Smith Tax and Insurance business receipts on an IRS agent that didn't even know what the company was. And then they also point to the fact,
Ms. Baldwin, what do you make of the admissions to owning these companies?
there was only an admission to owning one company, and that's the problem here. The government assumes that they were one and the same, but I mean, if you look at it, JA 1645, Benjamin Smith.
She only admitted to the agent that she owned one company, but what about the paperwork that Ms. Ray referred to, where she identified herself as at least having some ownership interest in the others?
I mean, I guess I disagree with that. She pointed to the EFIN application, and there she's listed as a delegated user, which is, I believe there's nothing in the record to indicate delegated user equates to ownership. And then even then, though, ownership isn't enough. If someone else got income, it is true as a matter of law that, zero Schedule C income is correct. And, they point to the biweekly paycheck, and JA 1500 also has a $25,000 check going to Benjamin Smith.
You said that if a company exists, if an entity exists, if someone else got the money, then that company is not required to do a Schedule C? Is that what you said?
Correct, yes. So the IRS records custodian, and I think Agent Archie also testified at 78 and 102, that, depending on the business form and structureship, there could be a partnership.
Under Section 162 of the Internal Revenue Code, income is earned by whoever owns it, the company. You can't say, I have a company, it's got money, but it really went to someone else. That company still would have to report it under 162 under the Internal Revenue Code, right?
Theoretically, all income, yes, has to be reported to the IRS, but the point here is, A, that she was charged specifically with not reporting sole proprietorship income, and also that, according to the IRS records custodian, there was never a search done. So actually, Smith Tax and Insurance could have reported the gross receipts and sales just on a different form. And then they also want you to extrapolate from 6 months of bank records back to 2013 and 2014 to sustain her conviction. And then I'll just turn quickly to the summary evidence, because there was a little confusion here. We did not object to.
About that last argument you made, was there evidence from Santa Barbara about transmissions to her, not the bank records, but just transmissions to her over the prior years for 13, 14, and 15?
No. So I believe what the government presented was the Santa Barbara records showing the fees that were sent to Smith Tax and Insurance as a result of returns submitted, but there's a gap. So we don't know how the Santa Barbara fees got into, for example, the New Dominion account in 2015. They did have evidence.
Well, that's tracing the money, but
Right.
we have the numbers that Santa Barbara reported depositing for each of those years. 1 year is 130,000, 1 year is under 100,000, and so forth.
Correct. We've never disputed. They proved that Smith Tax and Insurance made gross receipts.
So the question of proof then is, okay, that money comes in to a bank account, and the question is that into a company for which she has to file a Schedule C?
Correct. Yes, Your Honor. And so my time's over, but I really would just like to clear up the summary point, if I may. Just because I'm not objecting to the summary exhibit, demonstrative exhibit 145. That's fine. If Agent Archie had limited herself to, listen, the gross receipts were $300,000 and Ms. Smith reported zero. That's not what she did. She attributed the gross receipts to Ms. Smith as going to Ms. Smith. And that's what we have the issue with. That's what we're objecting to, not the exhibit itself, the inference that was drawn by the summary witness. And then I want to go back and I want to address the issue of our objection, was too general to cover this. And we would just disagree because, our objection here was this is improper summary evidence.
I understand, but you have got to give me the question and the objection. And according to your colleague, you objected once there was an exchange, and then the court gave the instruction. Now, she read the objection, and is there anything further that you objected to other than what she explained?
No, so it is that one objection.
Okay, well, now we have to look at the question, look at the objection, and then the curative instruction.
Right, and so
let's do that.
So the objection here was this is improper summary evidence, and the witness is usurping the jury's role by drawing her own conclusions. Now, these are precisely...
Okay, what did the court say? You objected to that, and the court said right after that, well, maybe it's gone over the line a little bit.
Yeah, but most of what you're doing...
And then you requested an instruction.
Yes.
And the court gave it.
Yes.
Okay, we're talking about one question. This witness testified as to a bunch of witnesses and over, quite a bit of time. And your whole argument relates to this question, to which there was a response and a curative instruction.
It might be a thin line, but our argument isn't that this one question went over the line. Our argument is a lot of this went over the line.
Now,
Summarizing the oral...
Tell us, you can't just say that. I read the transcript, and I found a lot of the questions good, fine. They were just perfectly fine under 611. And I do believe this conclusory stuff is inappropriate. But that was really very minuscule.
Maybe I'm burying the lead here, and so that one question we say, that is what gets us to the harm. That is what precludes the government from showing harmlessness. But there was still error, it may have been harmless, in allowing Agent Archie to summarize witness testimony the jury just heard for itself 10 minutes ago. And
it was foundational. The witness was trying to build on a statement that the witness heard and trying to be accurate about it, and then taking that evidence and linking it to data. And that was the whole purpose for setting that forth.
Our argument is that is an improper use of Rule 611A. That gets into the effective second closing argument from the witness stand.
Not drawing conclusions about the date, pointing out where that person's testimony, is referred to in the data, the complex data that was before the court.
Well, sure, it's packaging up it's packaging up the evidence already submitted nicely, but the jury didn't need that. And because the jury didn't need that, it got into this danger zone where they did cross the line and cause harm here. And then just point out, so this Agent Archie, she didn't even know the total amount transferred in the 6 months between accounts, JA 290.
Your appellant's counsel cross-examined her on that at trial, correct?
There was...
An extensive
Yes.
cross-examination at trial,
Yes.
including on that point.
Yes.
Bob, why did the defense offer a curative instruction when the court is out loud voicing some questions and concerns about where they were going and whether or not it was overreaching? Why you never bid against yourself? Well, why did you do that?
I guess there's a difference of opinion. I think some attorneys say, listen, we're not gonna, put all our eggs in the basket on appeal. It's like, we're gonna try and, cover this error as well as we can.
I don't mean it. I think you misunderstood. I'm not saying you lay down and roll over, but I'm telling the point is that you say, wait a minute, you're right, Your Honor. The objection, instead you said, okay, wait a minute, I think we can resolve this. Let's do a curative instruction. Let's make sure it's not sick before we offer a cure. You had a chance to prevent sickness. Keep it out, Your Honor. Instead, you say, well, I think we can do it. Let's cure it. Well, I don't understand that.
Your Honor, honestly, I don't either. I think I think both parties kind of, failed the district court here and could have done more. And then also we wouldn't be in this position we were. And so there was a bit of failing here in handling the summary witness, I think by all parties here. And so, but we would just say, we think we did enough to remedy it on appeal.
I appreciate the candor. Fair enough.
If there are no other questions.
Sure.
I have one question. Could you briefly respond about, to opposing counsel's argument about the drug condition of supervised release?
Sure, and I'll say, honestly, Judge Thacker, I thought your questioning kind of encapsulated our point here. There were two issues we brought to the district court's attention, both the vagueness, which that's actually the reason the Sentencing Commission did withdraw that condition, because it was pointed out by the Seventh Circuit as being a problem. And then also the fact, it's just not related to her. She doesn't have any history of drug use, so why are you going to tell her she can't go to a park where there might be a drug deal? And then even Judge Colliburn's like, well, I don't know why a probation officer would even tell someone they can go somewhere where someone's knowingly selling drugs. So that said, and Ms. Ray does a very good job of explaining why perhaps there is some reason why this condition is proper. But the problem here is that discretion goes to the district court. Okay, the U.S. Attorney's Office does not have the power to say this release condition is reasonable. That is the district court's job here. And the district court judge's explanation here really just doesn't give us a basis to find that this discretionary condition was reasonably imposed on Ms. Aminta Smith. So we would ask for, to go back and for the district court to give it another look.
Thank you, Ms.
Thank you, Your Honors.
Thank you. Thank you both, Ms. Baldwin, Ms. Ray. We can't come down and greet you as we would love to do, but know very much that we appreciate your help on this case and your presentation, and I wish you well and be safe. Take care.
Ms. Baldwin, you've been before us quite a bit, haven't you? Maybe I'm confusing you with someone else, but
I've been a few times, yes. I think only once before you, Judge Niemeyer.
all right. Well, I was going to try to latch on to our shaking hands earlier, and then again in the future when you come again.
Okay, I appreciate it. I look forward to the time when we actually
Definitely true for Ms. Ray.
Thank you, Your Honor.
I will proceed to our next case. Counsel, you can stand down for the moment. Okay, thank you. Mr. Lynn. Mr. Lynn, you may.
Thank you, Your Honor. Good morning, and may it please the court. Albert Lynn, on behalf of Appellant Antero Resources Corporation, I have with me Jamie Chapman from Antero. Antero's appeal in this case boils down to three legal questions, each of which goes to whether the company properly calculated royalties under certain oil and gas leases. In my time today, I intend to focus mainly on the first two legal questions because together they cover all but one of the leases at issue. I'll also address the West Virginia Supreme Court of Appeals' decision in Kellum, which issued after the briefing in this case completed. In short, that opinion is an almost self-consciously narrow opinion that reaffirms that Wellman and Tawney remain good law in West Virginia, but we think it did little else. Notably, it expressly declined to provide any further guidance on what those opinions mean or require. So, turning to the first legal question, which is whether Wellman and Tawney apply to market value leases as well as proceeds leases. I think the place to start with that analysis is that it's undisputed that Wellman itself created a new rule only for proceeds leases.
You know, I must have missed something, but I found the briefing by both parties to sort of chase down rabbit holes that we really didn't need to go down. We have, in this case, leases that are 7 leases or 6 leases that have the settlement language. We have one that has the flat, and there's no dispute about that, what track H, whatever it is. And then we have the other leases which don't have the settlement language, and you guys agree that they're gross leases. So really the issue here are these 2 through 7 leases which have the settlement language. Now, why do we need to go to Wellman and Tawney to read that contract? I mean, clearly, what they say very obviously is that if you do not address post-production costs, then the presumption is that the lessee carries those. But here, it was addressed in the settlement agreements. And so now the question is, what do those settlement agreements mean? And I think they're pretty murky, and we can address that. But this whole discussion about Wellman and Tawney still applies or doesn't apply, it's not relevant, is it? Because the contract here was, the leases were amended in 2015, and we're addressing that language. That's what we're looking at, right?
Not quite, Your Honor. I think, so there are essentially 3 categories of leases. One of them is, as Your Honor points out, leases 2 through 7 as modified by the settlement agreement, and that's the market enhancement clause that you referred to. That's for the settling plaintiffs. However, Your Honor, there's a group of non-settling plaintiffs to whom leases 3, 4, 6, 7, and 9 apply, and we don't agree that those are proceeds leases. I think everybody actually agrees that the unmodified versions of those leases for the non-settling plaintiffs are in fact market value leases. So that's why this question of Wellman and Tawney, in terms of whether it applies only to proceeds versus proceeds and market value, is relevant. There is a...
Well, I'm confused. 2 through 7 are the leases that were addressed by the settlement, right?
For the settling plaintiffs only, but there are actually some plaintiffs here who were not parties to the settlement agreement.
Well, then they don't have that language, right?
That is correct. They have the unmodified language.
They have the unmodified language which preceded the settlement.
That's correct, Your Honor.
And all of those did not address who bears the post-production costs.
That is correct, but they are market value leases in the sense that they say that the royalties are calculated based on the market value at the well or the prevailing price at the well, which is different as well.
What's that got to do with the notion that the lessee has the duty to produce gas and to market it? And those are implied covenants. It has nothing to do with, I know Wellman excluded the, limited its application, but still the principle was that if you don't address it and you have a common law duty to produce and you have a common law duty to market the gas so as to make it meaningful, then that you pay the cost. Now, you want to reverse that principle?
No, Your Honor. So I think the way that we approach this is we think there was a couple things. One, there was a background principle in place at the time that Wellman came into being. And Imperial Colliery, which is an opinion of this court that addressed the West Virginia leases, talked about market value leases as opposed to proceeds leases, and acknowledged that the netback method, even though those leases did not specifically talk about post-production costs, that is a way...
It uses different words, and I have trouble even figuring out the difference between a proceeds and a market value, because I assume that when somebody receives proceeds, he's receiving it at the market value at what he could pay. And the market value and what's paid, actually paid, are probably the market price, because the sale is the market. But that doesn't get that doesn't address my question, is if, let's call these the other leases, not 2 through 7. The other leases don't have this settlement language. The other leases don't address any post-production costs, right?
That's correct.
So the standard understanding that West Virginia seems to have, and I know in Wellman they announced it only as to proceeds, but the general understanding is that because there's a duty to produce gas and to market it, the lessee has that duty. The lessee has to pay, carries the cost of performing that duty. That's the underlying principle, and whether what they get paid for it or what the royalty is, seems to me, doesn't address that principle. That principle is basically the absence of a contract that addresses post-production costs. There's a presumption that says the lessee has to carry them.
Yeah, and if I may, so where we disagree, Your Honor, is that we think Wellman announced this rule, and it was a new rule. We think they announced this rule for proceeds leases.
I don't know if it's a new rule. They seem to recognize it. I mean, these leases have been going on for hundreds of years now, or 100 years, or whatever it is.
Your Honor, I don't think you can.
So they clarified the principle. Now, they did distinguish with some states, and they followed Colorado, and we understand all that. But that's a standing principle, and they did say, curiously, that we're only applying to proceeds leases because market value may raise some other issues.
Yes, Your Honor, and I think if you look at Tawney, it explains what some of those different issues are. And Your Honor, I think, and I understand that the distinction can seem a little murky, but I think the distinction is, so proceeds leases talk about, they contemplate an actual sale. And when a sale occurs, you get a royalty based on the actual money received. The difference is a market, and there's potential confusion with respect to proceeds leases that doesn't arise with respect to market value leases. I think there's a paragraph in Tawney that explains this, where they say, for example, if you have a lease that says gross proceeds at the well, so gross proceeds contemplates an actual sale. And what Tawney says is, in that situation, you don't actually know where the actual sale occurred. What if it occurred somewhere way downstream, but it still says gross proceeds at the well? That's confusing, right? It's contemplating a real sale, but the sale didn't necessarily occur at the well. That's why proceeds leases need this extra clarity. The difference is with a market value lease, where it says a market value at the well, it's talking about this hypothetical value at a particular place. It doesn't contemplate an actual sale, so you don't have that same potential mismatch that Tawney was talking about. And so I think that's the reason why Wellman only says it with respect to proceeds leases, because it's acknowledging and recognizing that when you're talking about an actual sale, and Judge Niemeyer, this is to your point, people would think, okay, there's a sale, and there was certain revenue that came from that sale.
Except there really aren't any sales at the well. That's what they said. That's no longer the practice, right?
Right, but as Imperial Colliery recognized, you can figure out what the market value at the well is, which again is a hypothetical value, even if there's no actual market at the well. And you do that by saying, here's where the sale was, here's the revenue that we got.
So with respect to these other leases, what do you want us to say about those?
Of course, Your Honor.
Don't argue the point why. Just tell me what you want for those leases.
What we would like you to say is to say that Wellman, according to its own plain terms, Tawney and Kellum, all of which reaffirm that same syllabus point and the limitation of proceeds, that rule and those requirements do not apply to market value leases.
Well, that doesn't help me, because that doesn't help what you're doing. The question is, do you then get to assess the proceeds?
We do.
Why?
What, do we
because
get to
don't you still have the duty to produce and to market?
Well, because when you apply the plain text of those leases, which use terms
They don't
like,
address post-production costs.
I understand, Your Honor, but I think if Wellman doesn't apply, then you apply the rule that is discussed in Imperial Colliery, where it says, and is also discussed in Leggett, in a part of Leggett that is still good law, that says the value at the well is something that can be determined by taking the sale price downstream and subtracting the costs that were incurred to get to that place. It's called the netback method, and that's how you figure out that hypothetical value. So what we would have you say, Your Honor, is one, Wellman and Tawney, by their own terms, don't apply beyond proceeds leases. And for market value leases, which simply contemplate this hypothetical value, you apply the rule that was embraced in Leggett.
All these other leases provide for royalties at market value at the well?
The unmodified, well,
Unmodified ones, the
yes.
other.
It's actually 3, 4, 6, 7, and 9. The one I'm leaving out is 5. We acknowledge, and no one disputes, 5 is a pure proceeds lease. So that's what we would say with respect to those, and that's why we've talked at length, Your Honor, to answer your original question, about the distinction between market.
So on these other leases that have that language, market value at the well, your argument is that at the well can be computed by working backwards from the ultimate sale price and
correct.
subtracting the costs.
That is correct, and we think that was recognized in Imperial Colliery. We think it's recognized in Leggett, and a part of that.
I understand your argument.
Okay, thank you, Your Honor. And so, just to sort of conclude on that argument, we think Wellman is very clear when you look at the syllabus point, and syllabus points, as this court well knows, is how the West Virginia Supreme Court of Appeals sets forth its principles of law. It limits it to proceeds. That syllabus point has been reaffirmed verbatim again and again, and the reason for it, Your Honors, is what we discussed, that there is a confusion that may arise with respect to proceeds leases that does not arise with respect to market value leases. And so with that, I'll turn to the Market Enhancement Clause, Judge Niemeyer, that you had mentioned. The district court, so the question, that is a pure...
You call it market enhancement clause, but I say it's a little more complex than that. You're talking about a paragraph that was added to the leases by reason of the settlement.
That is correct. Your Honor.
Okay, and that's a contractual construction. It's about 8 lines long, whatever, and, okay.
Yes, Your Honor. And so that's the provision that, for the settling plaintiffs, is what governs in these particular leases. And the question, because we concede it is a proceeds lease, the question is whether it satisfies Tawney. It's undisputed that prongs 1 and 3 are satisfied. The district court held as much, and that has not been contested before this court. So really the only question is whether it satisfies prong 2, which requires the identification of costs with particularity. The district court's problem with it was that she thought that the phrase other products was ambiguous. And we think there's a couple reasons why it nevertheless satisfies prong 2, but we can turn straight to ambiguity. Your Honor, with respect, we don't think it's really that, we don't think it's unclear what other products covers. The question that the district court raised was, does other products include natural gas liquids, which is something that's made from gas? And we think if you, for 2 reasons. One, if you apply the doctrine of a justum generis, which is how you construe catch-all clauses, as well as looking at the plain language that uses the different words products and form, I think what we think it's clear that other products is talking about things that are like oil and gas, but not forms of oil and gas. And we think natural gas...
Well, you guys try to distinguish between costs of immediate production from raw gas at the well. You talk about how you produce, get to natural gas liquids. You mix all these things in. You say one's an enhancement and one's a post-production cost. You talk about when they get at marketable form. In other words, that's the defining period when the gas gets at marketable form. But gas is sold at all forms. I mean, even in raw form, isn't it? And so it's hard to figure out. The question is, it seems to me you should get the benefit of your settlement agreement. What's difficult is whether there is a factual issue in the settlement, in that language.
So I agree with you, Your Honor. I think there's 2 questions here. One is the clause clear enough as a matter of contract interpretation to satisfy prong 2 of Tawney? There is a separate question, I think, once you decide that. Factually, right, on a case-by-case basis, well by well, product, whether the costs we are taking are enhancing in that particular circumstance. But I think really the first question for this court is, what does the clause mean, and is it clear enough on its face to satisfy prong 2 of Tawney? We think it is, because it identifies a long list of post-production costs. It says when we can take them and when we can't.
Is there an agreement in the industry of a cost to bring gas to marketing as distinguished from enhancement? Enhancement is beyond that, right? It takes gas that has, on which some money has been spent to get it to be marketable. And then there is another expense you can put on that, at a marketable product to enhance it, to increase the value and.
Yeah, and I think, Your Honor, to answer your question, not to avoid it, but to answer it, I think it's answered by the clause. The clause says enhanced to receive a better price. And so I think that's what enhancement means under the clause. If the costs that were incurred get us a better price, and that's actually what we do. Again, that's a factual question, Your Honor, that if this court is uncomfortable with answering and looking at the record, can send it back to the district court. But I think as to whether the clause is clear about what it contemplates, I think this is what it contemplates. It contemplates that if the costs are enhancing a product beyond its marketable form, and forms and product are different things, if it enhances it beyond its marketable form, by that it means to receive a better price, then we can take the post-production cost deduction. And there's a definite list of what those things are. If it's only a cost that is incurred to get the gas into marketable form, and Your Honor, to answer your question, yes, sometimes raw gas is marketable, but sometimes it isn't, right? And it's all gonna depend on the facts of the particular market. Sometimes there isn't a willing buyer for the raw gas, and in that case, then it wouldn't be marketable. So, but that's what it does. It says costs to get a product to marketable form, not deductible.
Well, maybe enhancement is included in that. In other words, maybe there is no purchaser available except for enhanced.
There may be, but again, I don't think there's a question as to what, I don't think it's ambiguous what marketable means, right? I think there's a willing buyer, that's what marketable means. Whether it's satisfied is a factual question. But what we really are interested in this court weighing in on is the district court's conclusion that she just couldn't make sense of what this clause is talking about. And we just don't think that that's true. We think it has two categories of costs: cost to get a product to marketable form. Products are things like oil and gas and things of that same level of generality: condensate, sulfur, minerals, things that come out of the ground. And you can modify, refine, and process those products, right? And get them to a marketable form. All that stuff, not deductible. Once it's in a marketable form, anything else we do to get a better price, that's enhancing. Those costs can be deducted. Whether that is true in a particular case is a factual question. We think the undisputed evidence here shows that we only took costs that were enhancing. But the more important question before this court, setting aside the factual issue, which we think is undisputed, the more important question before this court is the clause clear? And we think it is. You can apply the facts, but I think what it means is not in dispute, and I think that clarity.
Let's assume it's unclear, or let's assume it's ambiguous. We have a circumstance then where the default position is if you don't address post-production costs, then the lessee has to carry them. That's the Wellman principle.
Yes, Your Honor.
If it is addressed, then you can get post-production costs so long as there's some level of clarity that shows you're doing it. Now, there clearly is a settlement clause addressed at post-production costs.
Correct, Your Honor.
So it would seem that should get you into a new field.
That's correct.
And the question then, is it ambiguous, and need we resolve the ambiguity? And I guess the counter-argument is that Wellman or Tawney, I'm not sure which one, has these three criteria.
Yes, Your Honor.
But those criteria are basically an effort to say it's got to be clear you're addressing pre-production costs.
I think that's what it boils down to. Your Honor, I'm sorry, I've just noticed that I've been gone well past my time. Chief, if I could just give a quick response to it.
I'm sorry, you can ask questions.
Judge Niemeyer, I think that's exactly right. I think in prong one is the question, does the lease address post-production costs at all? That is satisfied, no one disputes that. And prong three is this question of, is there a method of calculation? No one disputes that that's satisfied. The only question here is, have we identified the costs with sufficient particularity? And we think under Wellman, Tawney, and Young, we have. And with that, Your Honor, I'll.
Thank you, Mr. Lynn.
Thank you.
Mr. Masters?
Please, court.
I make two requests. Maybe you could put the microphone on the desk there so it gets closer to you, and maybe
Okay.
if you're willing, you can remove your mask just during argument.
Thank you.
Yeah.
Well, I have a tendency to drop my voice after a while, so I'll try to keep it
Well,
up.
if you really get in a problem, you can actually lift the mic up and put it on the stand there.
Yeah, I'll
That's
go ahead and
something
do that.
I've done.
I'll go ahead and do that. All right, well, in the last statement that was made, that defense counsel mentioned was that everybody agreed that prong 3 was agreed that the lease or the enhancement clause passed that measure. This enhancement clause, and if you don't mind, I'll address that first. This enhancement clause was added to a contract that provided that these various deductions post-production could be taken. Those statements in that lease, the original lease, and that's the ones that were part of the settlement agreement that everybody had to re-sign. The reason for that enhancement clause was to address in a different way the right to take deductions. So what it really does, it starts off by saying that they will not take any deductions. It doesn't say we may, might. It says we will not take any deductions for all these things, all the way from the wellhead, all the way out to the point of sale, transportation, everything. And to make it marketable. Now, what is it that clause says? It says we will do this without post-production costs for oil, we'll do it for gas, and we'll do it for other products. If the defendant, in this case, Antero, which is a very successful big production gas company, then if they wanted to take deductions from NGLs, could they have not said that? So why did they put in other products? What other products besides oil and constituents and things of that nature, but why, the main thing, one of the main things they produce is NGLs. So why wouldn't they put it in there? What's clear about calling it other products if you're going to come back later and say, well, we really meant to leave out NGLs there. And that's what they say in their brief. We really didn't mean that this included NGLs. Now, then they come back and say, however, if we enhance a product, we enhance oil, gas, or other products, then we get to take the deductions. So what does that tell an ordinary, reasonable human being, person, if they're been talking about the fact they don't want deductions from their lease, from the products taken from their well? What does that tell?
I understand
They
that.
only want it when it's been enhanced.
Yeah.
Pardon? They only want to deal when it's enhanced. They're telling you what we're not going to do, the normal type things they lay out. We're not going to take that. But when we enhance, we will. That's what they're talking about.
Okay, but if they say they're going to do that if they say they're going to process it, transport it, market it and sell it, and we put it in marketable form, they're saying they're going to put NGLs in marketable form. So it is not, this enhancement clause is not simply to, it's modifying a lease. In that lease, it has them taking these different deductions. But in this enhancement clause, they are saying, well, we'll go ahead and do this. Now, they're coming down and saying, after that, that if we enhance these same products which are marketable, that's what they say, which includes NGLs, well, if it's marketable, that means they have put it in a marketable condition.
It's like you sell a sweater, it's ready to be marketable, but if you want to enhance it by putting stitched embroidery on it, then I've enhanced it.
True.
So that's
if you're
not.
talking about a
that's what I
sweater,
mean.
but in
Let's
this,
talk about oil too. It's marketable is short of enhancement. Enhancement is marketable plus,
but,
right? Would you agree with that?
well, once you get NGLs in a marketable condition, they are marketable at that point. So that means
Not necessarily enhanced in terms of the industry.
they're not,
For example, you can market unleaded gas, that's whatever. But if you make it super supreme, then you've enhanced it to some degree. That's why you look at the gas pump, you pay more for that. But that doesn't mean it wasn't marketable before that point.
but NGLs, Your Honor, are, if they're made marketable and they're ready to be sold. So that's what it means. So the fact that they go back and say, we will enhance if we enhance this, that means after it is put in marketable form, ready to be sold, then we're going to do something else. Well, they're not talking about, they're not paying for the NGLs at that point without taking deductions, I think is what I'm trying to get across. In other words, once it's made in marketable form as NGLs, it is ready to be marketed and sold at that point, and it is sold at that point. So if they do something after that, for example, if they transport it to Chicago as NGLs, like they did their gas, sometimes they would do that. We're not arguing about that, because they sometimes would transport their natural gas to other locations, and they charge for that extra, and sometimes charge the plaintiff. They do not charge the plaintiff for that unless the gas is, unless that by the transport fees is, makes the royalty less than what they could get back in selling it locally, I guess is the best way to put it. But in any event, we're not contesting that part. That's where that gas is enhanced, because they're transporting maybe to Chicago. So plaintiffs are not contesting that. But that's not what about, it's confusing what they mean. If they meant to say that and make it clear, then why didn't they just say, like Tawny requires, if we turn gas into NGLs, that's what they want to charge for. If we turn gas into NGLs, we're going to charge your percent royalty as costs for turning it from gas into NGLs. Okay? So that's what's at issue here. And that's not clearly stated. If it had been clearly stated, then they would have, and like Tawny requires.
Well, it seems to me it's harder for a reader, including us, to apply it to actual market conditions and product conditions. But that doesn't mean that we couldn't come to an understanding of the meaning. And if I understand that clause, and you can correct me, but if I can understand that clause, is the first part of the clause says they cannot deduct expenses to make a product marketable. But they can deduct expenses for enhancing that product to increase its price. And that actually would probably benefit both them and the lessor, because the enhancement would raise it and they would get a larger, probably a larger royalty, even despite the enhancement costs. And then the enhancement costs have to be reasonable, have been actually expended and reasonable. Now, the distinction is when is a product first marketable and what is an enhancement. And the document doesn't say that. But it does make the distinction between when a product's first marketable and when a product's enhanced. And to that extent, it can be understood. I raised with Mr. Lynn the question is this a question of fact? What's included in products that are just brought to market and products that are enhanced? What is the enhancement? I mean, every time you move it through a process, you're doing some form of enhancement, even to bring it to market, make it marketable. So that to me is a little bit confusing, but there is an agreement by the lessors to pay enhancement fees. There's no question about that. And if there's an agreement to pay enhancement fees, your effort is to try to say, no, we don't have to pay enhancement fees because it's not perfectly clear.
Well, the district court found it ambiguous on the second prong, as counsel mentioned. But the enhancement provision did not help the plaintiffs in this case, the lessors. In fact, they basically got near none of the value of the NGLs. The expert, Mr. Renicky, and some of his reports.
So you're pointing out that the agreement to allow the deduction of costs for enhancements, the costs use up the value of the increased value. Is that what you're saying?
That's exactly right.
Okay. But that was the agreement. I mean, the settlement agreement, it was reached in 2015, and whether it turns out to be perfectly good or not, it's not unconscionable. It's an agreement on who's going to bear certain costs, and that's what that settlement addressed. And as I understand it, and you correct me if I'm wrong, it purports to say that Antero cannot charge costs for making a product marketable, but they can charge the cost for enhancing a marketable product. Isn't that the way you read it?
Yes, that's what I'm saying. I'm just adding to that they said that in the first paragraph of this clause, and they used the same language in the second. In the first, I mean, they're calling the first they're saying they can take enhancements out of this by taking these various deductions, and they will not charge them to make it marketable. And they're saying that we will make your NGLs, or these other products will make your NGLs marketable. But then they've been taking deductions, and there's a different procedure for them taking deductions. But anyway, they've been taking deductions from the NGLs, and the clients are not getting any benefit, or did not get any benefit from that. So anyway, we believe it is definitely ambiguous, because two people can read that in different ways, and the fact of the matter is, I mean, if you take into account, it's modifying a lease which allowed them to do the same thing, which this was supposed to modify that, so they couldn't do the same thing, which is
well,
what they're doing.
why don't you address that? It's interesting to me. If I understand their argument, and I'm going to address only the leases that are not proceeds leases. These are leases that are not under the settlement. The leases that provide for market value, the payment of market value at the wellhead.
All right.
And apparently there's, what, 3 or 4 of those leases?
Yes,
Yeah.
yes.
And so their argument is, if I understand it, that the market value at the wellhead can be determined from the actual sale price or the market price further down the line by backing up the costs and getting to the market value at the wellhead. So that if a product can sell for $1 at the wellhead, if it's delivered, it's going to sell for $1.30. They say we can subtract the 30 cents for transportation and calculate the royalty on the dollar. Is that their view?
That's their view.
Okay.
They're relying on Imperial Colliery, the Fourth Circuit's decision. In that case was decided when FERC had jurisdiction with respect to prices and so forth. In that decision, one of the large issues in that decision was whether the lessee, the producer, had violated his responsibilities under the lease. So the lessor was and that lessee was taking a position that there was no market at that time. There was no market, and there was no way to calculate the market value at the wellhead. So the lessor, who was trying to show the damages, said, well, the expert said, well, we can reduce that value by taking these costs. Well, that predated both Wellman and Tawney, and in that case, it's entirely different, and the court did not consider the same issues as were existing in 2001 when Wellman decided that case, and in 2006 when the Supreme Court of West Virginia decided Tawney. So,
let me ask you, do you see Tawney as doing, Tawney reaffirms Wellman, right?
That's right. Well, it answered Wellman's questions too. Yeah. And because the question was left, Wellman was dealing with the proceeds lease. Right. And somebody, it doesn't really say where it came from. Somebody had brought up the issue about market leases or other types of leases. And so, rightly so, the Supreme Court in Wellman addressed only the leases that were proceeds, because that's the kind they were dealing with. Tawney came along after the experiences, and a lot of times people who are making contracts and people who are trying to enforce contracts and courts who try to interpret them and try to apply them. A lot of times experience shows both the parties, and if put before the court where the problems lie in different types of leases. Leases are supposed to be, when interpreting a lease, it's supposed to be strictly construed, liberally construed for the lessor, strictly against the lessee, and also if a document is prepared, a contract is prepared by one party, then the party that doesn't do the preparation is entitled to the benefit of applying it if it's not clear in favor of the party that did not prepare it. So there's two issues there, the rules. But in Tawney, there's two syllabus points in Tawney that address or basically repeat Wellman. One of those syllabus points, which in Tawney is syllabus point 2, doesn't say anything in there about proceeds leases. It just says leases. Obviously, in Wellman, that's probably what they were talking about. But anyway, the Tawney case specifically addressed, it was a class action, so it addressed numerous leases. And before the Tawney court was presented various objections by the lessee contending that the at-will leases should not be treated the same as a proceeds lease. And the court in its syllabus point specifically held
I
that-
thought a lease could be a proceeds lease. You could sell at the wellhead, couldn't you?
yes.
Okay.
There's no difference between, here, that's good, I mean, that's the point. Market value, there's no market anymore at the wellhead once FERC got out of that business. So the market is where it's sold. And so unless, I mean, here's the thing.
But you have a lease, that's a good point. The market is where it's sold, and let's say it's sold 2 stations down or 30 miles away or whatever from the wellhead. The question is, what is the market value at the wellhead? And I thought we concluded you could compute the market value at the wellhead by subtracting the costs of getting it to that 30-mile point.
The court,
Am I wrong on that?
well, the court, what the court had, that's the Imperial Collier case that I was mentioning earlier. That basically what happened was the lessee was saying no, and the lessor said, but they were fighting over other bigger issues. They were fighting about did the lessee violate the terms of the lease in other ways, and therefore would lose the right to the wells and so forth in that case. Their expert, I mean, all the court did in Imperial Collier said, well, yes, you can do that. But that is not being applied in this case, because that's just deductions. I mean, what it says is, what they're trying to do is say that's a formula for all leases, and that's not the case.
Well, I think the question, and this whole discussion has helped me some. I came in wondering what's the difference between market value and proceeds. And I gather the proceeds is an actual transaction where you receive the money, whereas the market value is determined by what is being sold for at a particular point. And so we have some leases here, not subject to the settlement agreement. We have some leases here that provide for market value at the wellhead, right?
Correct. So, but as Your Honor said, I mean, trying to distinguish that when the Tawney syllabus point says that at the wellhead in similar language is not enough to, I mean, similar language being, at one point it's got price. One of the leases had price, net of cost. In their type of leases that this rule, the three prongs of Tawney applied to, and there is, I guess what I'm saying is, Tawney answered the question left in anybody that questioned the Wellman decision, whether it applied to at the wellhead language, whether it applied to.
That doesn't help us here, does it? The distinction is not at the wellhead, but whether it's proceeds at the wellhead or market value at the wellhead. and Wellman made a distinction between those, which I didn't fully understand, but I think I understand a little better today. I think you guys are in a different league. I don't know, you talk about these oil and gas leases that use all these terms and fracking gas and distilling it and NGLs and marketing and making it marketable, and yet raw gas can be sold if there's a market for it. And it's not easy to get your arms around it.
Well, what defense is trying to do is ask this court really to rewrite or overrule Tawny?
No, we're not trying to rewrite, but we are trying to distill what the rules are for the different types of leases.
I understand. I'm just
And I
saying,
think we have in one category, the lease is modified by the settlement agreement. And so
Oh, in this
we
case.
have to construe that clause and determine whether the district court was right on that. Then we have these leases that were not modified by settlement. And they're of different types. We have some that are market value at the wellhead and some are proceeds. Proceeds are governed by a Wellman clearly, right?
yes.
Yeah.
And and Tawny answers the question about the other leases because he did not
I
distinguish.
looked in Tawny, I couldn't find them addressing the distinction between market value and proceeds. That was the footnote in Wellman.
I understand.
Do you think it did?
I think it did from the standpoint that it provided that at the wellhead, it didn't say at the wellhead in a proceeds lease, at the wellhead in a market value lease, and at the wellhead and in any particular lease.
So you
Said at
think
the well,
because they were talking generically,
yes,
that includes both?
right. I mean, I think if they didn't want that, then they would have addressed it there and accepted market value out. But as the court mentioned earlier, at market value at the wellhead is not any significant difference than proceeds at the wellhead because the market, if the market's out in, 10 miles down the road or something, that doesn't answer the question, I mean, because they're going to get the market value anyway. I mean, that's all they get in proceeds leases, is whatever the proceeds are. So trying to limit that, the reach of Tawny is not, Tawny applied to basically all leases, and I think if you read it correctly, read it as it's written, it applies to all leases, oil and gas leases, with respect to the three prongs of the things that have to be in there if you're going to charge the lessor with these costs. And that includes method, that includes specificity, that includes all the three prongs in the Tawny criteria. And the leases that they mentioned, I don't know how much time I have, if any.
You don't have any time left.
Well, let me just say that the Tawny court left really no doubt. I mean, they're trying to say that market value leases are different. They're not at the wellhead. So in any event, the enhancement clause, as I mentioned, is the court found it ambiguous, and it can be read in more than one way. So I'll rest for the time being.
Mr. Lynn?
Thank you, Your Honor. If I could, I'll start with the very last point about what Tawny stands for. Syllabus point 1 of Tawny is the syllabus point that reaffirms verbatim syllabus point 4 of Wellman, and that's the one that includes the proceeds limitation. So what Tawny says is, Wellman is, of course, good law, and it establishes this rule for proceeds leases. It then answers the question, what does it mean to provide otherwise, right? Because Wellman says, there's a presumption, but you can provide otherwise. And then the question that Tawny answers is the at the well language sufficiently specific in a proceeds lease? Because that's what Wellman was about. And the answer that they give is, no, it's not, Your Honor, for the reasons that we discussed earlier, because you could have this mismatch between proceeds, where that sale occurs, and if you say proceeds at the well, it's potentially very confusing, and that's why there has to be more specificity, and that's where the Tawny factors come from. So that's what Tawny is about. And so, Judge Niemeyer, to your point, at the well language could be used in a proceeds lease, and that's why the Tawny factors exist. But we're talking about market value at the well. How you calculate that, I think, is acknowledged in Imperial Colliery. It's also acknowledged in the West Virginia Supreme Court of Appeals' decision in Leggett, where it talks about value at the well and how you can use the net back method to get to value at the well. Now, to be very, very clear, Leggett was talking about that language in a statute, but it was doing the linguistic interpretation. It says value at the well is not an ambiguous term to us. We think you can get that by netting back from the actual sale.
The West Virginia Supreme Court a couple of months ago came down with another opinion. Does that add anything to the mix?
So that's the Kellum decision, Your Honor. It reaffirms Wellman and Tawney as good. There was some question after Leggett because
Leggett tended they read it as criticizing their.
Yes. There was a part of Leggett, not this part that I was just talking about, the value at the well. There was a different part of Leggett that said, we think Tawney and Wellman were not well reasoned, and Kellum says in the majority, no, we don't think that's correct. Wellman and Tawney are still good law. But that's all it says. It doesn't say anything else. It doesn't touch this court's Young opinion, which applied Tawney. And it also reaffirms verbatim that language.
What does Young add to that?
I think what Young adds is what Young said is when you read the plain text of Tawney, that's a quote at 208, that it doesn't require Einsteinian precision, and that you only have to identify which costs and how much will be deducted.
When reading the plain text of Tawney, where in Tawney does it say it's limited to proceeds leases?
I think it's syllabus point 1 of Tawney that reiterates.
Syllabus points, they're not the opinion.
They are, Your Honor. We cite the Recht case.
Okay, so syllabus point, which one?
Syllabus point 1.
And it says?
Limited to proceeds. It says, if an oil and gas lease provides for royalties by proceeds, comma, unless it provides otherwise, and then it goes on to state the presumption. Syllabus point 1 is a repeat of syllabus point 4 in Wellman. And Judge Thacker, to be very, very clear, syllabus points are the law in West Virginia. It is different from...
Who writes a syllabus?
The court does. The court does. And they are required by Constitution to write.
So they write their opinion and they write syllabus then?
They do, and oftentimes...
Well, I'm glad we don't have to do that. We have to raise our pay.
Yes, and Your Honor, I will just say from experience, oftentimes at argument, you will get asked by the court, what is the syllabus point you would like us to adopt here? It's a quirk of West Virginia law and the Constitution.
Can you cite, in an opinion, can you cite a syllabus point?
Absolutely.
Does the court rely on that?
Absolutely. In fact, the syllabus points are more persuasive or binding than language explaining it in the opinion.
Right, it prohibits dicta, really.
Right.
Our West Virginia judge knows all that.
Syllabus point 1 is quoting Wellman.
Yes, Your Honor, and it includes that proceeds language.
Right.
Right, and that's my point. So it reiterates the limitation to proceeds that Wellman had adopted and explained in footnote 3. I'm rapidly running out of time. I will just simply, on the settlement, the market enhancement clause, 2 very quick points. The first is, it is in fact undisputed that prong 3 and prong 1 were satisfied. The district court at JA 2004 to 2005 says and holds prongs 1 and 3 are satisfied. It's 2004, 2005. And my friend in his brief did not contest that. He has not challenged that holding. So the only question is prong 2, and really what it boils down to, as Judge Niemeyer set forth, there's a question of, is the clause clear? And then there's a question of, what happens when you apply that language to the facts? And we freely acknowledge that where that line between marketability and an enhancement, when something becomes marketable, is a factual question. Now, we think it's satisfied here, but it's a factual question. But the more important point here is the clause ambiguous? And we don't think it is. The main question is, what does the phrase other products mean? And does that include...
I don't understand why that's even a problem, one way or the other. Because if you're able to delineate costs that make a product marketable and costs that enhance it, if you can make that delineation, and you've answered the whole clause, and it doesn't matter. Other products is basically, is not to limit the whole settlement to oil and gas.
That's correct, Your Honor. That's exactly right.
And it doesn't matter what's in there. The question is any product that is made marketable is included there. And enhancement is any product that is enhanced to increase its value.
Beyond marketability.
So the distinction is between making it marketable and enhancing, I think. That's the way I see it.
Yes, Your Honor, as the Chief
And
said,
Chief Judge Gregory seemed to,
marketable plus, right? I
his
think.
questions
Yes,
focused on that.
and so I would say that, you know, the question is, it's about making a product into marketable form, right? A form, that's what it says, marketable form, and then enhancing it beyond that marketable form. That's what that clause means, and it's not ambiguous, and we think it satisfies prong 2.
Could be an Alice in Wonderland type thing, you know. It's a marketable form and enhancement may not be any difference, but. All right.
I've exceeded my time, and so we'd ask this court to reverse the judgment for the plaintiffs and to, at a minimum, remand with instructions for the court to proceed consistent with your rulings.
Thank you, Mr. Lynn. Mr. Masters?
Your Honor, going back to,
What are you standing up rebuttal on? You only have rebuttal on the fraud issue.
Cross appeals. Go ahead, Mr. Masters.
I'm sorry, I was getting ready to address the fraud,
Right,
if that's what you mean.
yeah.
Okay. All right, well, so the issue with respect to the fraud is, or the fraud cause of action that was alleged, is that the court dismissed that early on based on the complaint. And by doing that, then the plaintiff was not, was put in a position where that was dismissed, so therefore we were limited in our discovery with respect to that. What was presented and our plaintiffs relied upon in terms of their products, they were initially brought suit against by Antero in a petition suit, and they ultimately ended up signing a lease or leases modifications with respect to their property. And one of those issues was they were discussed and, as they understood, resolved by the settlement agreement and the lease they signed, was that there would be no deductions taken, including on the NGLs. So our complaint obviously didn't go into any details because it didn't have any details. And I pointed out in my briefing.
Let me ask you this. If that's the allegation, apparently they understood that there'd be no deductions made, and they signed this settlement agreement. And the settlement agreement says there will be no deductions made except for deductions for enhancement.
Well, that goes back to.
And that's in writing. And the question is, doesn't that override any claim for fraud or undermine any claim for fraud that they thought they were going to pay no expenses?
The enhancement clause, it goes back to what I explained to the court in the previous argument. A fair reading of, I understand what you're saying about the enhancement.
It had to provide for something. I mean, it says, it makes an exception for enhancement expenses, right?
It does, but then again, what are they enhancing? I mean.
Well, that's a good point, but my point is, they could hardly say they were going to be no expenses across the board ever. They agreed to say no expenses to make it marketable, but they agreed to deduct expenses for enhancement. Now, I don't know if they asked what enhancement meant when they were negotiating.
Well, I mean, that's part of the reason that
But
the court.
it's hardly fraud, is it, at that point?
At that point, it clearly violated Tawney, violated, I mean.
Yeah, but everybody's sitting there looking at it, and you have different understandings of what was agreed to, but the language is there and everybody signed it.
It is, but, I mean, I think everybody agrees. They agreed to make marketable other products. They didn't, if they had just said oil and gas, stop there, then everybody would have understood. If you process the gas and turn it into NGLs, then that might be enhancement. You know, going back to why in the world would Antero limit their enhancement clause to 2 little paragraphs? The lease is several pages. Why would they, if they're going to modify the lease, why would they prepare that? They prepared that. And why would they start out saying, we're not going to charge you for making all these things marketable? Well, if they make NGLs marketable.
I know, but I understand. We're getting back to what that means, but the question is, where was anybody misled by ending up with what you argue is ambiguous language when you were negotiating with Antero through your attorneys on that clause?
Because our clients believed there was not going to be any deductions for NGLs. They believed that. They believed that when they signed that, that modified the lease so that there would be no deductions, no deductions with respect to the NGLs. And so when they didn't.
Well, if that's what the contract means, then they're breach of it. But at this point, it doesn't mention NGLs, and somebody has to determine, as a matter of fact, whether NGLs falls under the making the product marketable or whether it's an enhancement, right?
Right, but I don't think there's any factual issue. What they did was they did not enhance the NGLs. They did not do that. You could say they enhanced the gas.
Let me ask you, just as a matter of side thing, is an NGL gas that comes from the well that's compressed to make it liquid?
Well, they go through a processing. They go through a processing of the gas, and they turn that into it. It's liquids from the gas that's contained in the gas that's transported. Usually it has a higher BTU value than the gas. Than gas that gets on the interstate pipeline. So they run it through processing, and some of it has to be processed anyway. So it runs through there, it's fractionated, and turned into NGLs. And that's a market, that's another product from the same thing that comes out of the gas when they make oil, gas, and NGLs. It's all coming from these plaintiffs' properties. And the plaintiffs are entitled, they're entitled to their royalty from that without deduction, because it, for one thing, according to Tawny, if that lease doesn't clearly say that, then they're not entitled to take deductions. And why, and like I said, why would a big company prepare a clause, an enhancement clause, that's not at least clear enough to say in it, we're going to take deductions out of the NGLs from if we produce NGLs from gas, we're going to take deductions. Why wouldn't they say that?
That'd been nicer, we might not have been here.
We wouldn't be here, and that's the point. That's what contracts are supposed to be. They're supposed to be to avoid disagreements over it.
And your lawyer could have said, what does enhancement mean? You brought us to the table too, didn't you?
I'm sorry.
You're saying they didn't do that. Why does a big company do this in 2 paragraphs and all of that? They had lawyers, your client had lawyers, and
Oh, it's not saying enhancement. I don't think there's any question. Our clients
You could have said enhancement such as NGLs.
could have said that. They could have said, we're taking
Or
into,
you could put other products such as enhancement. In other words, you could have, if NGLs was the real important issue at the negotiations, it could be put in as an example in either products or enhancements.
Yes, but according to, yes, it could.
We wouldn't be here.
We wouldn't be here on this case, no. Might be another case, but we wouldn't be here on this case. So what I'm saying is it's really insane to think that we are here talking about this. It really is. Because all they have to do is put it in.
It also is a maximum that said the law won't do for you what you won't do for yourself,
Yeah, it says that.
right?
It says that.
You're sitting at the table, you could have done this for yourself.
I wasn't
Instead,
saying.
you want us to rewrite the contract.
No, I'm not suggesting that you rewrite the contract. I'm trying to tell you, or tell the court, that this clause does not meet Tawny by any stretch. I don't agree that it doesn't meet Tawny that it meets Tawny in any way. I don't. And like I said, I think, as it's put in my brief, I think that the way it's written, they're not allowed to take deductions on NGLs.
You think an NGL is not an enhancement?
Not in this case.
No, I mean generally, it's.
No, it can be. Oh, absolutely it can be. I mean, I've seen contracts written.
Well, that makes it even harder for us.
Well,
Whether it's
the point I'm making is that our clients, not my clients them, because I wasn't involved in this, but anyway, I've seen many enhancement clauses. I have never seen one like this. This is it's misleading, because if they want to.
Negotiated with attorneys, though. I mean, that's.
I don't know who they negotiated with.
Well, they signed it there. I saw the.
They signed it.
I don't want to say it would have been nice if they would have been a little more explicit. Sure, we wouldn't have this case here, but every contract case usually ends up that way. Somebody didn't say something that maybe could have been said.
I don't think this boils down to my clients. Most of them were elderly people.
Well, it may or may not. It depends what the contract says. But
It
they-
should depend
they
on what the
agreed to it.
contract says.
They agreed to it.
But according to Tawny, it has to be specific. It just doesn't meet specificity. This doesn't meet particulars. This doesn't meet anything in Tawny. Tell you the truth. The court found prong 2 as being not meeting according to prong 2. But if you read the court's full opinion, she went through very particularly and looked at every aspect of that clause. And she found she went through each lease and specifically.
Yeah, you're back arguing the other part now.
Well,
She found against you, didn't the court found against you on your cross appeal, right? That's why you
yes, she
cross
did.
appeal.
But she ruled before.
We're finished on that case. You came back up because you're telling us why
Well,
it is fraud.
that's true. I'm sorry.
Yeah, you did. Let's keep it.
All right. So anyway, let me sort of finish up how this happened that I consider to be fraud, okay? What they did was they did not advise the plaintiffs here that they were going to compare. First of all, they didn't advise them they were going to take deductions. It was hidden in there, and according to the way that our clients believe that, they're ordinary people, they believe that this fixed the leases, which had already said they were taking these deductions. They thought this fixed that. So, and what they would do and did was they did they called it a balancing between the value of the gas and the value of the NGLs with residue gas. There's gas left over. So those two things, they were balancing that, and they pay on the better price. The problem was, then all this time they were taking deductions off of the NGLs. And that was learned in the litigation.
They treated the NGLs as an enhancement.
They did. They did. And that's where the problem is, the biggest part of this case is that they did that. So the fraud part is they misrepresented that they were going to do that. And the enhancement clause, I believe, was one thing that misled them. And so anyway, I've a lot of arguments in my brief, which I won't try to go to because of the time. Thank you, Your Honors.
Thank you, Mr. Masters. Mr. Lynn, both of you, thank you for your arguments. Can't come down and shake your hands, but know that we appreciate your arguments present. Wish that you be well and be safe. With that, we'll ask the clerk of the court to adjourn the court for today.
This honorable court stands adjourned. Sine die, God save the United States and this honorable court.